Order item of non-restricted and item partition coming.
In item number 6, the order is deferred. It will be delivered on Monday.
6
6.
lots.
In item number 8,
Lots.
8 PP is there.
Yes.
Item number 8, order will be delivered on
Yes.
25th of April.
Lots.
And in other matters, 1, 2, 3, 4, 5, 7, 9, 10, 11. 12. In 12, interlocutory application is disposed of. 12, 13, 14, and 15. Though Mr. KL gave certain material today itself, that has to be incorporated in the orders.
Lots.
So I have to make changes, certain changes, but the decision remains same.
Lots.
The petitioners are allowed to go on bail of rupees 50,000 with 2 sureties of like amount with certain conditions which are mentioned in the order.
Lots. Much of it. Much of it.
In item number 6 and 8, since Third Learned Council, the delivery of order is referred till 24th of April 2020. In item number 6, it is on 23rd. You have to mark 23rd. Item number 8, it is 25. Item number 30. Item number 30 is allowed with certain conditions.
Your Lordship. I beg to mention item number 27, Your Lordship. I am not the conducting council. He is made with some medical emergency, Your Lordship.
27
CD
diary receipt. 27 na
27.
diary receipt.
CD was called for at least adjourned for
Heard.
today, Your Lordship.
Heard Mr.
S.A. Hussain.
S.A. Hussain, who is submitting on, who submits on behalf of the
DJ Halwai.
Mr. D.J.
Halwai.
Haloi, who is the conducting counsel of this case and submits that due to some medical urgency, the conducting counsel is not in a position to appear before this court today and prays for an adjournment. The prayer is allowed. Let this case be listed
केतिया लगे
Tuesday or Wednesday, any day.
on 24th of April.
I am on interim, Your Lordship.
The case diary which is available shall be retained till next day. The interim order shall continue till next day.
Much of.
Item 16.
Number 16.
Similar matter was yesterday notice was issued, Lordship. 107 matter, Lordship. Case 19 is the earlier order, Lordship. Exactly same notice, only MRKC different, Lordship.
What are those cases? You are appearing in other cases also, no?
Other cases, Lordship.
Item number 16, 17,
18
18,
and 31 to 38, Lordship. Supplementary, same, Lordship.
16, 17, 18. Item number 31
to 38, Lordship.
to 38. It will be same order. I am dictating the order. Again, it's now. Heard Mr.
MK was
M.K. Hussain, learned counsel for the petitioner. Also heard Mr. What is your name?
J.K. Goswami, Lordship.
J.K. Goswami,
Additional Senior Government Advocate
learned additional senior government advocate,
from all the respondents.
appearing for all the respondents.
Lordship, it is Lordship on behalf of 2, 3, and 4, Lordship. For 1, Lordship, my learned friend will appear.
Okay. Mr. J.K. Goswami appearing for
2, 3, and 4.
the respondent number 2, 3, and 4. Also heard Mr. B.B. Gogoi, learned additional public prosecutor appearing for respondent number 1. Where is the order?
Page 20, Lordship.
This application under section,
Lordship. Can I submit, Lordship? May I submit, Lordship?
yes,
Yes, Lordship. Lordship, in this case, which is cited by the by my learned counsel, Lordship, it appears that the impugn notice issued in present petitioner nothing has been mentioned in regards to the section 111, Lordship. But here in this case, Lordship, and also it is stated that not accompanied by any application under section 107 of Criminal Procedure Code, Lordship. Now, Lordship, if I am not throw from instruction, Lordship, whether the relevant complaint was sent to the petitioner or not, Lordship, the interim order may not be considered at this stage, Lordship. Kindly give me 1 week time, Lordship. 1 week, not 3 days time, Lordship. Only 3 days time. And I will take the instruction. After obtaining the instruction, I will submit before this honorable court, Lordship. On that, at least, Lordship, regarding the stay, Lordship,
okay.
kindly consider on
This
that.
application under section 482 of the Code of Criminal Procedure has been filed by the petitioner, namely Muhammad Osman Ali, impugning the notice dated 28/3/2024 issued by respondent number 3 in MR case number. What is, where is the MR case?
Lordship, MR case 11, Lordship.
Where have you mentioned?
Page 11, page 1, cost title, Lordship, step and their part.
MR case number 11/2024. MR case will be different in other cases. MR case number 11/2024 under section 107 of the Code of Criminal Procedure, 1973. Learned counsel for the petitioner has submitted that the petitioner has received the impugn notice issued by the respondent number 3. However, it is also submitted that before issuing the notice under section 107 CR of the Code of Criminal Procedure, the issuing authority has to make an order in writing setting out the substance of the information received, the amount of bond to be executed, the terms of which and the duration for which it is to be enforced, and the number, character, and class of securities, if any required. However, in the impugn notice issued to the present petitioner, nothing has been mentioned regarding compliance of section 111 of the Code of Criminal Procedure, 1973. Learned counsel for the petitioner has also submitted that the impugn notice was also not accompanied by any application under section 107 of CRPC, and therefore the petitioner is in dark as regards on what basis the proceeding under section 107 CRPC has been drawn against the petitioner, and hence he has prayed for calling for the case records and also prayed for an interim protection in the meanwhile. On the other hand, learned senior government advocate,
Additional senior,
additional senior government advocate, Mr.
J.K. Goswami.
J.K. Goswami, appearing for respondent number 2 to 4, has prayed 2 to 4, has
Yes, Lordship.
prayed for some time so that necessary instructions can be obtained in this regard. And he has also submitted that the prayer for interim relief may be considered after he obtains the instructions. Considering the submissions made by learned counsel, additional senior government counsel, the prayer is allowed. Let the scan copy of the case record of MR case number 11/2024 be called for. No formal notice need to be issued to the respondents as all the respondents are represented. Let this matter be listed again on
Lordship, any next week, any date, Lordship.
suggested date,
Lordship, 25, Lordship,
25th.
25th. Extra copy maybe.
The petitioner shall furnish requisite numbers of extra copies to the counsel for the respondents.
Others matters are also similar.
Same.
That's the Lordship.
In all other matters which I have, that is 17, 18, 31, 32, 33, 34, 35, 36, 37, 36, 37 and 38. The MR number will be different and name of the petitioner will be different. Others things will remain as.
In the, at least status for till 26, Lordship.
Lordship,
Wait,
26.
Wait till
Yes,
26.
yes, Lordship.
Otherwise, then of course, as similarly situated person are
No,
No,
stay
nothing
alone.
force. You have
It
to
is
only
not.
appear, otherwise you will suffer.
Yes,
Wait for till
Lord.
26.
Lordship. Must have.
Mandate 25. 19 to 19 to different as anticipated bill.
Item 19.
Here 19, none appeared. The early, last occasion, it was directed to take instruction whether any case is registered against the petitioner or not, my lord. We have to take instruction, my lord, after some time, after some time.
Okay, after some time. 19 after some time.
Item 20.
Lord, this matter was heard by your lordships. A very small question of law involved. But when the person is not charge sheeted and he has been freed by the prosecution. Now, in order to, my lord, if you collect further evidence in the matter, in that case only you can book him and go for further investigation. But in this case, what happened? My lord, I was named accused in the FIR. Well, the charge sheet was given. I was not charge sheeted. That means he was not sent for trial. Now, I filed an application because my vehicle was involved. For Jimma of that vehicle, that custody was given to me. Then I went to the police for release of the vehicle to do the certain formalities. And on that particular date, police has arrested me. And then I filed an application for bail. On that day, they have said there are certain materials. Now, on that date, my lord, I will take your lordships from the record. There was nothing against him.
What is the date of arrest?
The bail, my lord,
Date of arrest.
on
On which
on
date?
3rd February. my lord. And your lordship will find the forwarding report is on 4th February. And what they have said.
Page?
Page, my lord, 44. And the ground of arrest, your lordship can listen. Sufficient evidence has been found against the arrested FIR name accused. He confessed his, your lordship kindly see this line. He confessed his guilt before local villagers that he is involved in transportation of illegal drugs in his vehicle and got huge loss due to seizure of drugs. He was smuggling drugs from a long time. The number 3, his arrested driver sent videos of cordon and Naka checking to him before seizure. The number 4 is he is not complied the notice under section NDPS Act. Your lordship, this person, he appeared before the court on 2 occasions on 6/7/2023 for the Jimma of the vehicle, then again on 27/2023. During that period, I will never say that he was absconding. Now, these are the all flimsy grounds they have taken just to protect themselves. Then he's not complied, the notice now, these things are there. Then your lordship kindly come to page 46. He was produced before the court, order dated 5/2/2024. Has your lordship got that?
Yes.
Case record is put up today, seeing the bail petition being filed by the petitioner Biplab Devnath seeking bail for the accused Nazrul Islam. Heard the learned counsel for accused petitioner as well as so and so, fixing 7/2/2024. Then later on, supplementary case record of Bajri Chara PS case number so and so along with relevant documents are forwarded to this court from learned Chief Judicial Magistrate Karimganj. Now, your lordship kindly see they have just started to fabricating the my lord evidence against him. Let the same be tagged with the case record. Accused Nazrul Islam is produced from jail through video conferencing. Then again, the next page later on. On the same date, seen the prayer made by the inspector officer in charge, RK Nagar Police Station for recording the statement of the accused persons, namely Rajesh Urang and Shamjit Ravidas, under section 164 CRPC, in connection with the instant case corresponding to Bajrichara PS case number so and so. Peruse the relevant papers. The learned Chief Judicial Magistrate Karimganj shall do the needful for recording the statement of the aforesaid accused persons under section 164 CIPC and shall get the same sent back forthwith. Now, my lord, the learned special judge totally misconstrued the provisions of law. My lord, under what provision of law, my lord, the police can do some mischief because of various reasons, because of their personal interest. But the court, should the court do that? Well, under what provision of he is asking the Chief Judicial Magistrate to record under section 164? My lord, can the court, my lord, be a party to make a fabricated case? Exactly this thing happened. My lord, he is asking the Chief Judicial Magistrate to record. That means there is no material till 3/2 when I was arrested. And now you are trying to, my lord, fabricate this case.
No. IO has made a prayer before the special judge for recording of 164 statement.
My lord,
Special judge, instead of recording himself,
you
has,
sent to Chief Judicial Magistrate.
he had sent it to.
No, my lord, can it be done? This is totally dehoves the provision of law, dehoves the provision, the mandated by the apex court. I will take your lordship to that. Now, in order to say, my lord, there is no fetter so far police is concerned to go for a further investigation. It is amply clear, my lord, under 173(8). It's very clear they have power. But this unfettered power, can it be done without any control? But because of that appeals code waiver in 17 NSC, you must file an application before the court because court must be satisfied what the materials you have. Otherwise, it is the police at their wisdom, they can do anything illegal. So therefore, I'll take your lordship to the decision of the appeals court. The other day, I took your lordship to those. But first, I will take your lordship to 1979's Supreme Court. I think it's on record,
Judgment
but
is there. It is there.
79 2 SCC, I will take your lordships to paragraph 20 and paragraph 21. I'll read paragraph 20, my lord, at phase. Paragraph 20, my lord. Anyone acquitted with the day-to-day working of the criminal courts will be alive to the practical necessity of the police possessing the power to make further investigation and submit a supplemental report. It is in the interest of both the prosecution and the defense that the police should have such power. It is easy to visualize a case where fresh material may come to light, which would implicate persons not previously accused or absolve persons already accused. When it comes to the notice of the investigating agency that a person already accused of an offense has a good alibi, is it not the duty of that agency to investigate the genuineness of the plea of alibi and submit a report to the magistrate? After all, the investigating agency has greater resources at its command than a private individual. Similarly, where the involvement of persons who are not already accused comes to the notice of the investigating agency, the investigating agency cannot keep quiet and refuse to investigate the fresh information. It is their duty to investigate and submit a report to the magistrate upon the involvement of the other persons. In either case, it is for the magistrate to decide upon his future course of action depending upon the stage at which the case is before him. If he has already taken cognizance of the offense, but has not proceeded with the inquiry or trial, he may direct the issue of process to persons freshly discovered to be involved and deal with all the accused in a single inquiry or trial. If the case of which he has previously taken cognizance has already proceeded to some extent, he may take fresh cognizance of the offense disclosed against the newly involved accused and proceed with the case as a separate case. What action a magistrate is to take in accordance with the provisions of the CRPC in such situation is a matter best left to the discretion of the magistrate. The criticism that a further investigation by the police should trench upon the proceeding before the court is really not of very great substance. Since whatever the police may do, the final discretion in regard to further action is with the magistrate. The final word is with the magistrate is sufficient safeguard against any excessive use or abuse of the power of the police to make further investigation. We should not, however, be understood to say that the police should ignore the pendency of a proceeding before a court and investigate every fresh fact or that comes to light as if no cognizance had been taken by the court of any offense. Now, these are the lines I am stretching much. We think that in the interest of the independence of the magistracy and the judiciary, in the interest of the purity of the administration of criminal justice, and in the interest of the committee of the various agencies and institutions entrusted with different stages of such administration, it would ordinarily be desirable that the police should inform the court and seek formal permission to make further investigation when fresh facts come to light. Then para 21, as observed by us earlier, there was no provision in the CRPC which expressly or by necessary implication barred the right of the police to further investigate after cognizance of the case had been taken by the magistrate. Neither section 173 nor section 190 lead us to hold that the power of the police to further investigate was exhausted by the magistrate taking cognizance of the offense, practice, convenience, and preponderance of authority, permitted repeated investigations on discovery of fresh facts. In our view, notwithstanding that a magistrate had taken cognizance of the offence upon a police report submitted under section 173, the right of the police to further investigate was not exhausted, and the police would exercise such right as often as necessary when fresh information came to light. Where the police desired to make a further investigation, the police could express their regard and respect for the court by seeking its formal permission to make further investigation. So therefore, my lord, till date law is amply clear. You have a right under section 173 subsection 8 that you can go for further investigation, provided in the meantime you have obtained sufficient materials. Now, in this case, your lordship will find there is no material on the date of the arrest. Subsequently, my lord, they are trying to develop a case, there are some materials. Now, my lord, further to this case, I'll take your lordships to another case. Where back in
Okay, the
1995,
material against you is only 164 statement,
164, and that after the
which
period,
was recorded later on.
later on, my lord, 7-2, and the evidence was taken on possibly 9-2. Now, can it be? Wait, let me finish. You take your. Then, my lord, the question would be, where is the materials on that date? Then your lordship kindly see 1995, 1 SCC. Earlier, I did not give it to your lordship. The lordship reiterated same thing. There must be an application.
This is.
First thing, my lord, there must be an application before the court. Paragraph. My lord, I'll take your lordships to paragraph 7.
Yes, para.
Paragraph 7, I just want to show from this case that this was the practice that when there is a further material, first thing you must take leave of the court. Now, your lordship can see para 7. The purpose of the submission of the police report with the details as mentioned above is to enable the magistrate to satisfy himself whether on the basis of the report and the material filed along with the police report, a case for taking cognizance has been made out or not. After applying his mind to the police report and the material submitted therewith, if the magistrate is satisfied that cognizance of the offence is required to be taken, he shall proceed further in accordance with the provision of the Code of Criminal Procedure. Section 191B of CRPC provides that a magistrate has the power to take cognizance upon a police report of such facts as are provided therein, on being satisfied that the case is a fit one for taking cognizance of the offence. Therefore, if the police report and the material filed therewith is sufficient to satisfy the magistrate, the wording your lordship is satisfy the magistrate, means he will have to be satisfied with the material. That he should take cognizance, his power is not fettered by the level which the investigating agency chooses to give to the report submitted by it under section 173(2). Merely because the prosecution had filed an application after submission of the charge sheet seeking permission to file supplementary charge sheet, it could not affect the jurisdiction of the magistrate to take cognizance if he was otherwise satisfied from the material placed before him, along with the charge sheet that cognizance of the offence was required to be taken. It is the jurisdiction of the magistrate and magistrate alone to decide whether the material placed by the prosecution with the report charge sheet was sufficient to take cognizance or not. The power of the magistrate to take cognizance cannot be controlled by the investigating agency, whose duty is only to investigate and place the facts and the evidence before the magistrate. Now, against that, my lord, they moved before the Honorable High Court. My lord, High Court has toppled it. Then the appeals court said the view of the High Court is wrong, because it is up to the magistrate when he is satisfied with the materials on record, he can take the cognizance under section 190. Even though there is an application by the investigating officer seeking permission for further investigation. Now, this is the position of.
No, I could not get yours.
My lord, the application was filed. My lord, taking cognizance, my lord, after police has submitted the report, I mean, there is whether there is enough materials to proceed against the accused, or if there is no material against the accused. Now, on the basis of that report, the police can take cognizance of the matter under section 190.
Magistrate
Now-
can.
A magistrate can. Now, after that, my lord, if on the same date, the investigating officer files an application seeking leave from the court that I want to go ahead for further investigation. Nonetheless, the magistrate, on the basis of the report given to him by the police, he can take cognizance. That, my lord, now this part of the order was challenged before the High Court. High Court has said magistrate is wrong because when he has filed an application for taking leave of going further ahead, because further investigation is required to be given, therefore the magistrate should not have taken cognizance. The Supreme Court has said, no, magistrate has done rightly, the High Court is wrong. So therefore, the question is, it is totally up to the magistrate. If he is satisfied on the basis of materials on record placed before him, he can go ahead for taking cognizance of the matter. Now, therefore, this line I have taken to your lordships to show that if the police want to go ahead for further investigation, he must file an application before the court, because he will have to take the court into confidence. Otherwise, my lord, the police may do many things because they have unfettered power. Without any materials on record, they may say there are materials, so let us go for further investigation, as it happened here. They have wanted a huge chunk of money which I could not oblige them. Because of that, now there is, as a lordship has seen, on the day when they have arrested me, what are the materials? You did not come up before the court, so these are the materials before him. Now, you want to manufacture a case against me, and the special judge also helped them. Special judge has directed, go ahead with taking the evidence under section 170-64. Then, my lord, the next case I will take your lordship, 1998 5 SCC.
What should have been done by the special judge? First, the IO should have recorded the statement of
no, my lord, before
witnesses, and thereafter,
IO should have filed an application seeking leave. My lord, making the.
but for filing application, some material has to be there.
He will have to satisfy the court, because I am taking to your lordship 98 Supreme Court, but the lordship has exactly said that. Because what happens, my lord? Police can do many things. This is an instance, my lord, what they have done. There is nothing against me. You wanted certain things to be given in certain manner. I could not satisfy you. That what, because they will have to protect them. Because the OC who has done it.
Now, one query. What these two witnesses have stated in
My lord,
160.
that is there, your lordship kindly see. I have annexed that. This is the extrajudicial confession. Your lordship may see at page 50, 51. It is in vernacular, my lord. Page 50, my lord. Typo in English. Yeah. I think your lordship understand Bengali, my lord. Page 50. আমার নাম ঠিকানা উপরোক্ত সত্ত্বে আমার জবানবন্দি এই যে বিগত কিছুদিন পূর্বে
He is Rajesh Shoran.
witness, his name is
Rajesh.
one is Sanjit, one is Rajesh. Yes,
You are reading Rajesh.
yes, my lord.
Okay.
বাসিন্দা নজরুল ইসলাম চুড়াইবাড়ির একটি পান দোকানের সম্মুখে আসিয়া আমার সাথে নিজের পরিচয় দিয়া জানায় যে তার গাড়ি নাম্বার সোয়েনসো নেশাযুক্ত সামগ্রী ভর্তি ছিল, তাহা পুলিশ জব্দ করে এবং তাহাতে তার বহু টাকার লস হইয়াছে। সে আমাকে প্রলোভন দেয় যে নেশার সামগ্রীগুলা চোরাইবাড়ি এলাকা পার করাইয়া দিতে পারলে সে আমাকে টাকা দিবে। সে আগেও নেশা সামগ্রী ওই এলাকা দিয়ে নিয়ে গিয়েছে বলিয়া জানায়। Now this is the kind of evidence, my lord, extrajudicial confession. These are, my lord, as your lordship knows, these are stock witness of police. My lord, when they, my lord, this witness is given, huh? My lord, this is the witness, my lord, in other cases also, in many of the cases I have seen, the stock witness has given this type of evidence. Now, can your lordship repose any confidence on this sort of, and what way it has been done? On third, when you have arrested me, there is nothing against me. When you found that you will be in trouble, now you are manufacturing all these things. And on the top of everything, my lord, whether you have obtained anything, my lord, that is, that I will take your lordship to 1998 5 SCC. I think it is there with your lordships. If it is not, my lord, I will provide another.
1998 5 SCC is not there.
2 to 3, my lord, I'll provide one. I'll take your lordships to paragraph 24.
Yes.
From a plain reading of the above section, it is evident that even after submission of police report under subsection 2 and completion of investigation, the police has a right of further investigation under subsection 8, but not fresh investigation or re-investigation. The government of Kerala was also conscious of this position, evident from the fact that though initially it stated in the explanatory note of their notification dated so and so, the consent was being withdrawn in public interest to order a re-investigation of the case by a special team of state police. In the amendatory notification quoted earlier, it made it clear that they wanted to further investigation of the case instead of re-investigation of the case. The dictionary meaning of further, when used as an adjective, is additional, more, supplemental. Further investigation, there is the continuation of the earlier investigation and not a fresh investigation or re-investigation to be started ab initio, wiping out the earlier investigation altogether. In drawing this conclusion, we have also drawn inspiration from the fact that subsection 8 clearly envisages that on completion of further investigation, the investigation agency has to forward to the magistrate a further report or reports and not fresh report or reports regarding the further evidence obtained. Your lordship, kindly see the language.
No, which line?
My lord, in drawing, your lordship, read
Yes.
from there, in
Yes,
drawing this conclusion, we have also drawn inspiration from the fact that subsection 8 clearly envisages that on completion of further investigation, the investigating agency has to forward to the magistrate a further report or reports and not fresh report or reports regarding the further evidence obtained. Now, when you obtain the further evidence, you produce it before the court being satisfied will tell you that, okay, you can go ahead for further investigation. And your lordship, there is striking difference between three things. Further investigation means continuation of the earlier one. And so for fresh investigation or re-investigation, that is with the domain of the constitutional courts. The session court or the magistratal court, they cannot do that because the constitutional court means your lordships, the high court and the Supreme Court. That is for depending on the facts of each cases. Now, these are the things amply clear. Well, first thing what they will have to do, that really there was a further investigation, they got certain things. Now they want to continue the earlier case because at that point of time there was no material against him. Therefore, those persons were not sent up for trial. Now, after some time again, they found there are some material and quite so melodic, many of the cases it happens that way. And that's why the terms and concept of supplementary charge sheet has come. Now here, whether that sort of things were there and whether the police has complied with those things or they're doing at their whims. You know, I may go to say that whether the police should not be taken to task in those sort of cases. Otherwise, your lordship kindly see, they have unfettered power and it is expected this power should be utilized for the proper purpose, for the true and fair investigation. Because if the investigation is not fair, well, the trial will obviously fall, as you've seen. The prosecution mostly of these NDPS cases, your lordship will find ultimately 80% of the cases, they get acquitted because of their lapses. Now here, what they have started doing, Lord, you have the power. That power will have to be exercised in terms of the legal provision. The mandate of the appeals court is very clear. You'll have to file an application before the court so that you can't do anything whimsically. Because this is a stringent provision, it must be, my lord, by complying all the provisions of law, you'll have to take the law into consideration. Therefore, your lordship has seen what kind of evidence they have procured and when they have procured. And my lord, another thing your lordship kindly see, further investigation after taking evidence in the trial is not like making an inquiry and take a 164 my lord statement. That will not do, my lord, because it will attract section 319 of CRPC. And 319 also speaks of in what way, my lord, the appeals court in a case, my lord, that case I do not have now, but I can, one decision was there in the morning you gave me. Your lordship, just 1 minute, your lordship. Bihar, yes. I read. One judgment, my lord, the Supreme Court, way back in 1996, 4 SCC 495. Now, in a Patna judgment, they have quoted in paragraph 8.
Citation is 1996 for SCC.
96 4 SCC, wait, just a minute. 1996 4 SCC 495. This is Raj Kishore Prasad versus State of Bihar. I'll read paragraph 8 from there. I don't have that, but I'll Patna decision there, the lordship has, my lord, enumerated that paragraph. May I read and then I'll give it to your lordship.
Okay.
From bare perusal of the aforesaid provision, it is clear that it operates in ongoing inquiry into or trial of an offence. In the case of Raj Kishore Prasad, that is 2006 SCC, subsection 1 of section 319 makes it clear that it operates in an ongoing inquiry into or trial of an offence. In order to apply section 319, it is thus essential the need to proceed against the person other than the accused appearing to be guilty of offence arises, this is important, my lord, arises only on evidence recorded in the courts of any inquiry or trial proceeding before a magistrate under section so and so, so and so. Now here, inquiry, my lord, if it is constituted to be inquiry, the session special judge has directed to the CGM to take an evidence under section 164. If it is taken to be an inquiry, then also, my lord, it's not a legal inquiry, because when they have started doing it, I was arrested on 3/2. Then I was, my lord, the forwarding report was given on 4/2. Then I was produced before the court on 5th of February. On 7th, my lord, they have said there is evidence to be taken. So this inquiry is no inquiry in the eye of law. It is, they are just fabricating a case. Now, this case also, your lordship, it helps our case.
Where is the charge sheet?
Yes, I'll take your lordship to that.
In charge sheet, what was your status?
Yes. Your lordship may see the charge sheet as page. At page, my lord, 31. Your lordship may see at page 34. Last part, your lordship will find particulars of accused persons not charge sheeted. A is Jyoti Paswan, he is the owner of the another vehicle. And my name is S.K. Nazrul Islam, he is the petitioner here. He is the owner of vehicle number 29B35386.
You are Nazrul.
I am Nazrul Mehru. Page 34, your lordship will find.
Why you were not charge sheeted? Any reasons mentioned?
My lord,
No
that
reason has been mentioned.
there
Actually,
is-
they have to mention reasons.
my lord,
at-
these are possibly not there, my lord.
19, subclause 19. That why charge sheet was not filed. It may
Yes.
be for various reasons.
Not there, no?
Okay, your status was for whatsoever reason charge sheet was not laid.
Yes. The owner of the vehicle. And there is, my lord, after investigation, possibly they did not find anything. That's the reason, otherwise why they will be so kind enough to me. Otherwise, my lord, it's an APS case. Why they will release me? My lord, in legal parlance, it can be said to be a discharge also. Although your lordship may think that in a judicial proceeding, the word is used as discharge. Now, whether, my lord, I'd like to make my argument that way also. When you are not finding anything, maybe the investigator.
Now, at that point of time when charge sheet is filed, there
Yes.
may not be anything against you.
Exactly, my lord.
In
Therefore,
further investigation, something may come out.
yes, that power.
So
is
your
there.
submission is that further
least it-
investigation ought to have been after leave of the court.
Exactly, my lord. That's
Permission of the court was not taken
Exactly.
and no material was there before the arresting authority on the date when the arrest was made.
Exactly. Precisely, that is my
It
point.
was later on collected
Later on,
in
collect.
form of the 164
My-
statement.
my lord. Exactly, precisely this is the point.
But now there is material.
Now, material, my lord. Now there is another question, my lord. The material which one has to be, my lord, applied in this case as further investigation. That must be by way of evidence taken in the trial. Now,
Yes.
whether it can be, this material can be said to be a material taken from the trial. Trial hasn't started even. So therefore, these are the things, my lord, whether at this stage they could have arrested me. That is the simple legal questions, my lord. Other things, those are a question of merit, my lord. Inappropriate. One thing, my lord, we could have come up for question, but then these are the matters that I don't think fit case for question. The only thing for a limited purpose of enlargement on bail, whether there are sufficient materials for further investigation, and in order to go for further investigation, what one has to do, that will have to be complied. The mandate of the appeals court that you must take into confidence the court first. You must file an application there. You will have to satisfy the court what are the materials you have obtained so far. The 1998 Supreme Court is very categorical on that. So therefore, my lord, this is my submission. And my lord, hope this is a case of bail.
The contraband was found in your vehicle,
Yes,
but at that time you were not there.
I was not there.
What is your submission as regarding this fact that
My lord, while
it was without your consent?
while taking the materials by a driver, where they are taking from where, I am not in the know of the thing. My lord, therefore, if those things are very clear,
And whether driver has implicated you?
no. driver hasn't. My lord, in that case, I would have been charge sheeted.
Yes, Mr. Bashir.
Lordship, in all humility, Lordship, in the earlier occasion also the matter was part heard, Lordship. But that day is because the matter was looked after by another additional PP, but I am not going to submit that. I have gone through the record, but Lordship, not the entire record. But Lordship, where my learned senior has stated regarding the section 67 and along with the 164 statements that was been recorded thereafter. Lordship, here also in the page
No,
51,
his first plea is that
Lordship.
the petitioner was a,
He is the owner of the
He-
truck, Lordship.
he-
There are three numbers
his
of truck.
status was not charge sheeted, accused against
Lordship.
whom during investigation no material was found.
Yes, Lordship. Yes, Lordship.
Then you have closed the investigation and
Lordship.
submitted the charge sheet
Yes, Lordship.
against the other co-accused.
Lordship.
Then to go for further investigation, his submission is that you should have taken leave of the court.
Yes, Lordship.
Without that leave, and for taking the leave for further investigation, some material has to be there,
Yes, Lord.
which would necessitate the further investigation.
Lordship.
His submission is what I have understood, that when he was arrested, no additional material was there
At that point of
at
time.
that point of time.
Right.
After his arrest, you procured two witnesses, recorded their statement that the accused has made confessional statement, extrajudicial confession before those.
Lordship, that was 164 statement.
Yes,
Yes, and that is by the, as per the order by the learned special judge, Lordship. Then that was recorded. And from that part also, Lordship, regarding the 67 statement, from the petition, in the petition, the page number 51, Lordship. Page number 51, there is a note in the last part after the statement of the deposition, that is the statement of Sanjit Robidas. That is in the page 51, Lordship.
yes.
Yes, Lordship, may I read it out, Lordship? Note,
Yes.
after recording statement, it is learned that the owner of the vehicle register number so-and-so, namely Nazrul Islam, came near Suraibari area, that is the Tripura Assam border, to pass illegal drugs with the help of local villagers. Nazrul Islam also confessed that his vehicle having so-and-so registered number, which is loaded with codeine phosphate, is seized by police and getting huge loss. He also shared his mobile number so-and-so to him to get any favor from witness. As per the statement, it seems that he is involved in the case. Further, it is to be noted that several times did an IO of the case send notice under section 67 NDPS Act in this case to Nazrul Islam, but he did not appear, which shows that he is involved in the case. So Lordship, that note is also there. So Lordship, actually, I'm not able to go through the entire LCR. To some extent, I have gone through. Lordship is allowed, and my learned senior has no objection in this regard. Maybe I may give some time just to find out all these things, whether the 67 was there, whether that part was there or not, whether the investigation in that part. Otherwise, Lordship, my senior has already make his submission on the law point regarding the investigation. His question is on the part of the investigation. That is without taking the leave of the learned.
No, you are seeking time.
If Lordship on that part, because
No, you
Lordship,
should have mentioned it
Lordship,
earlier,
yes,
because we have heard it length.
yes, because Lordship, the matter was part heard, and I was not there, and I got the Lordship. This is the order. That is who was appeared.
You take time till second half.
Okay, Lordship.
In
Okay.
second half.
Yes, Lordship. Till then, I can go through entire record.
Okay.
Lordship. Yes.
Because we have already.
Yes,
heard it.
Lordship. I need some time only to go through the entire.
Okay,
Yes.
we'll take it up. Let him go through the record.
Well, only thing regarding 67, my lord, as my learned friend stated, on 2 occasions I was before the court for the Jimma of the vehicle. They never said,
But that, from where it can be found out that you went to take Jimma of
the
the.
order of the court, my lord, I'll take your lordship to that. We have annexed it on 2 occasions. I was before the court, I was there. He never said, I'm absconding. He could have said. Your lordship will find,
You appeared before the IO.
yes,
That
twice,
is
my lord.
revealed from the record.
From the record, I will show you.
Okay,
On
okay.
six,
We let him go through.
My,
Yes.
therefore, those submissions should not be made, my lord, at least where to assist your lordship only.
Let him go through the
Yes.
record.
No, not.
May please, your lordship. Lordship, this is the same matter as in item number 3. This was the co-accused. 3 years, 2 months, 18 days behind the bar, 1173 days. And parity is not the only ground, lordship. Medical report was called for. He is suffering from some ailments and he needs to be operated, not only treated.
When you were arrested,
2/2/21,
3 years,
2 months, 18 days.
the co-accused case number is
BA 4136/2023.
now what is the other submission apart from incarceration?
Lordship, medical ground. The reports are in the record. He needs to be treated urgently.
What is the ailment?
Ailment, I think it was regarding renal cyst, and all renal cyst documents we have annexed along with the petition. And in the medical report, it was something with the testicles, hydrocele or some word was there.
Okay.
With regard to granting bail to the other co-accused, lordship, this is not a law in case of bail. I have submitted my written argument. One Tarun Kumar judgment is there. Lordship may see the page 52
No,
of
but
the
Tarun Kumar says
process to see the materials against the each and accused.
every accused, and parity is not applicable
In
if
case of-
suppose wrongly somebody has been
that
released
is-
on bail.
That is in paragraph 20. Yes, lordship, this is also,
If wrongly has been, that benefit the co-accused will not get.
yes, lordship. Now, lordship may come to page 52,
52 of the petition.
bail application. His name is Surendra Kumar. Page 52, paragraph 60. Married law,
Yes,
paragraph 60. That the seize 117.650 kgs of ganja, which is a commercial quantity seized from the truck bearing registration number so and so, and which was conscious possession of Surendra Kumar and 2 others.
Surendra Kumar is the driver or
Yes, he is the driver. And he is the petitioner here, before your lordship. Number 6, page 6, paragraph 61, that Surendra Kumar confessed his voluntary statement that Bimal Dev Burma gave seized ganja to deliver it from Agartala to Bhagalpur, and the ganja was loaded in the truck bearing registration number so and so, which was loaded with paper. Surendra Kumar confessed in his voluntary statement that Mokim and Khushbu Rahman was with him in the truck bearing registration number so and so, and all were paid rupees 75,000 for delivery of ganja from Agartala to Bhagalpur. That is voluntary statement given by Pradeep Roy. Surendra Kumar and Mohammad Mokim used to came to him and asked about the goods to deliver ganja from Tripura, load in the truck bearing registration number so and so. Therefore, I sent them to go down of Titan Saha to load the waste paper on 31/2021. On 31/21, the morning, Surendra Kumar, Mohammad Mokim, and 1 other persons came to him, and after loading the waste paper in the truck bearing the so and so to further deliver waste paper in Siliguri. 63. That as well voluntary statement given by Titan Shah, Mohammad Mukim and other 2 persons came to his godown and loaded the waste paper in truck number so and so, but they have no driving license. on asking Pradeep to inform him that another persons, namely Surendra Kumar, will deliver the said truck from Agartala to Siliguri to deliver the waste paper. 64, that as per statement given by the independent witness Sri Rabul Varman and Sujit Sarkar, that 12 packets of ganja which were loaded in weight 117.650 kgs recovered from the said truck bearing registration number so and so. Surendra Kumar, Mohammad Makim and Rahman were present in the truck at the time of interception. That on analyzing the CDR number so and so of Surendra Kumar, it was found that Surendra Kumar was in contact frequent from the supplier of the seized ganja, Bimal Verma, Devarma and Devendra Pal and Mokim during the period of the seizure. So Lordship, he was driving the truck and from his conscious position, the contraband, which was a commercial quantity, was seized. Now Lordship, with regard to second ground, regarding medical ground, Lordship, in Guwahati, the art of medical treatment are available. Lordship, may direct the jail authority to, if
No, medical ground may not be a very strong ground for.
Lordship,
and with regard to possession, Lordship,
No,
yesterday,
with regard to long incarceration.
Lordship, it cannot be a ground. I have submitted 2 judgments on this regard before your Lordship. Probably Lordship has gone through. That in case of heinous crime, long incarceration, it cannot be a ground for granting bail to the petitioner.
Lordship, Surendra Kumar was not the driver. It is mentioned in page number 29. The driver was someone else. He was not the driver.
From
He
his
said to
conscious
be-
position, Lordship,
was
at least to
said-
see.
He was said to be present in the truck, but he was not driving the truck.
From it is, Lordship, the materials collected, it is revealed that he was driving the car from Agartala to Siliguri. And yesterday, Lordship, I have submitted one judgment of Om Prakash Yadav, where on similar ground, the person, from his conscious position, contraband was seized, then Allahabad High Court granted bail, then the Union of India approached Supreme Court. Supreme Court.
No, but that was on different ground.
Lordship,
That was on.
no, Lordship, may please to see paragraph 8 of the judgment.
Putul.
Lordship, in that case,
Paragraph
if
eight.
Lordship wants an elaborate hearing on this matter, a date may be fixed, Lordship.
Kera?
Paragraph 8.
No, yes, it is that,
Bail was
They-
granted on the ground that they were not aware about the.
yes. but
yes.
Here, this is not.
Here, Lordship, from his position, it was recovered.
No, here their plea is different. Here their plea is long incarceration.
No, because this is the one of the ground taken by them.
This
So-
ground is.
No,
This,
Lord, regarding.
regarding the ground that they are,
He was present in the truck. So,
that is enough
yes,
to presume that he was,
in conscious position of the materials. So that is the law laid down by the.
yes, on that I don't have a different opinion. Regarding long incarceration,
Log incarceration, Lordship, in Satyendra Kumar until Supreme Court says that 436 capital will be applicable in case of NDPS. Earlier it was not applicable. And 436 Lordship, may I place before your Lordship.
no, not under 436.
436 say.
436 is applicable.
After Sanjay Prasad until Lordship. Earlier it was not applicable in case of NDPS. Lordship, what 436 capital says.
But 436, whether it precludes that otherwise on long incarceration, 436 says
No.
that half of the punishment,
Yes, Lordship, that is my Lordship, in not a single judgment, long incarceration has been defined by the Honorable Supreme Court.
yes, that court has to see.
Yes, court is to see. And when 436 capital is applicable, then Lordship has to, we have to go by that. That the 436 was introduced only the purpose of when the trial is delayed. Then there was a few judgments are there before 436 was incorporated in the CRPC.
No, that I have addressed in the,
No, this is my simple Lordship. It is up to your Lordship how Lordship will deal with. But in my humble submission, maximum punishment will be considered in case of NDPS. Maximum punishment 20 years. If it is there, Lordship, then Lordship can consider. Then it will be applicable. Otherwise, in my humble submission, in case of heinous crimes, long incarceration cannot be ground. when there is a delay in trial for 3 or 4 months. And one judgment I have relied, that Allahabad Bar Association case, where Supreme Court is in paragraph 27 to 36 dealt with this matter. How the trials are delayed, who is responsible, whether it can be a ground, or whether High Court can direct the trial court to complete a trial within the specified
No,
period.
no. Regarding that, I'll not hear you because you have options of once I have given, in this case, I may hear them because they want, if they want a adjournment in case of long detailed hearing.
No, I cannot make any objection, Lordship, to that. If they
So-
make prayer for adjournment, I have no
So
objection.
in this case, I am adjourning. But on the ground of long incarceration.
No, if your Lordship is stopping me from argument, then I.
No, I am not stopping you. Nobody can stop you.
No, Lordship said that I will not be allowed to address on this point.
No. Because their submission is that what I have understood that the co-accused has been allowed to go on bail on the ground of prolonged incarceration. Then,
Because that judgment has not come yet. I have-
yes. So
I-
you have an option to go to challenge that order.
No, that is up to department, whether we will challenge or not,
No,
that is.
listen to me. They are taking the benefit of that judgment. That is their submission, that once this court has allowed the co-accused to go on bail on the ground of long incarceration, same ground is applicable to him also.
Lordship.
That is their submission, what I have
But
understood.
in my humble submission to rebut their argument,
And once they take this objection, and once this court has given a finding against you on the ground of long incarceration, your only option is on to go, the option.
no, we know the option, Lordship. That is always open to the, either to the petitioner or the respondents.
Yes.
But Lordship, in a individual bail application, I have every right to place my submission.
Yes.
Whether it is go against me or it will favor me.
Yes,
That is the
then let us hear it at length. I am adjourning it on their request. Heard Miss N. Sultana, learned counsel for the petitioner, also heard Mr. SCKL, learned additional public prosecutor, learned standing counsel NCB. On the request of learned counsel for the petitioner, this bail application is adjourned for the day. Let it be listed again on,
Lordship, 23 April, 23 can be.
Lordship, on 23 to 26, I have parted matters in almost all courts.
29th April.
29th may be fixed. 29th, yes, Lords. Monday.
Okay.
Attention.
What's even item 22, before my learned friend starts, the bail of co-accused Bikram Dev Burma was rejected by court number 21. This is the order. So as per the Supreme Court's.
It should go to that
should
court.
go to that court. Lords.
So here in this case, Lordship, one was allowed by the court number 20, just placing, Lordship.
But it,
One, Lordship.
that means this one is the third court.
This is the third court.
It can never come to third court. It has to go
To the,
either first or second court.
yes, Lords.
So registry will decide which.
Yes, Lords.
One court allowed the bail application of co-accused. Probably that was not brought to court number 21 because this
Lordship,
judgment.
that was brought and Lordship may please to see. This was same submission was made before court number 20 yesterday. Lordship may please to see the where I brought to the notice of the honorable court.
Which one was the first order?
Let's see, last order is court number 21, Lords.
Yes, this bail application should have been decided by the first court.
Yes, Lords.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. SCKL, learned Standing Council NCB. Learned Standing Council NCB submits that as the bail application of one of the co-accused, namely Bikram Dev Burma, has been rejected by a coordinate bench of this court, this instant application should be considered by the said court, which has already decided the application filed by the co-accused. At this juncture, learned counsel for the petitioner has pointed out that prior to the bail application, which has been referred by the learned Standing Council NCB, two numbers of the co-accused, namely Bayar Debabarma and Sahison Debabarma, had approached another coordinate, had approached this court seeking bail, and their bail application was allowed by another coordinate bench of this court on 1st of December 2023. And therefore, according to the guidelines of the apex court, all the bail application ought to have been considered by the court which had earlier considered the bail application of the co-accused. In view of the submissions made by learned counsel for the parties, registry is directed to put up this matter before the appropriate bench.
Okay.
Registry will decide.
Yes.
Applied.
Mati Thakur.
Yes, Your Lordship. This matter also be taken as along with item 20(2) minor. Both showing clear.
Who will be,
My lord.
okay, Bashir. At 2 we'll take it up. I'm taking a short break.
Lord.
May I please your lordship, 439 application. FIR is at page number 15, your lordship. Allegation under section 354, 354A clause 1, subclause 1 and 2. 354A subclause 1 and 2 are available, your lordship. The allegation under 354, your lordship. The FIR was lost on 1/4/24. I was called by the police on 1/4/24.
Where is the FIR?
Lordship at page number 15.
1/5.
1/5, your lordship.
You were called by the police. Yes, now you make submission.
Lordship, I was called up by the police on the same day. I appeared before the police. Police directly arrested me on the same day, your lordship. Lordship may also see the forwarding at page number 16, your lordship. 354, your lordship, the punishment is below 7 years. I was not served with a notice under section 41A, your lordship. Neither there was any reason in the forwarding, which is at page number 16, your lordship, that why 41A notice was not served upon me. It is nowhere mentioned, your lordship. Lordship will also appreciate the real fact of the case, your lordship. Lordship, my wife runs he's a landlord, your lordship. He has a rented premises. I decided house number 4 Betkusi, and I have a rented premises which is at Lalungaon, your lordship. And the informant's husband has not been paying rent from the last 3 months, your lordship. As such, on 31st, I went there to my rented premises. I have an argument admittedly. And I have asked them to vacate the premises, but they have not done that. Thereafter, on the same day, I approached before the Gorsik police station. I have annexed the FIR, my FIR, Your Lordship, which is at page number 19. As the informant's husband was not vacating my premises, I approached before the Gorsik police station. And on being knowledge about this FIR, they have approached the
What is the date of offense alleged against you? Is
Lordship.
1/4. Okay.
The incident occurred on 31/3, Your Lordship.
The alleged incident,
Occurred on 31/3, Your Lordship. I went to my place of rented premises, Your Lordship. The cause of action was civil in nature, Your Lordship. They were not paying my rent from the last 3 months. That was the only cause of action, Your Lordship. Thereafter, on the next day, on being known about this FIR,
your FIR was not registered.
my FIR was not registered, Your Lord. On preliminary inquiry, the informant husband was called by the police. Because the matter was civil in nature, he was not paying my rent, Your Lordship. I was feeling that they should vacate my premises after paying my rent, Your Lordship.
Yes, Mr. Yes,
Yes, my lord.
How many days you are behind the bar?
Lordship, on 20 days, Your Lordship. Lordship will appreciate whether my further custodial interrogation is required, Your Lordship.
So far, my lord, the witnesses are concerned, my lord. In 164, my lord, she has reiterated the same facts that has been narrated by her in the FIR, my lord. And so far, other witnesses, my lord, who were also in the tenanted premises, my lord, they have stated that though they have not seen, my lord, they have heard from the informant that the accused tried to do bad things with her, my lord. If your lordship may kindly peruse those 2 witnesses, my lord, from the lordship, I have flag mark, my lord.
No, whether further custodial detention is necessary after 20 days. Because statement have
Yes,
already been,
investigation is going on, my lord.
they have already recorded the statement of victim and
Yes,
victim
164
statement under
records.
section 164.
164 recorded.
Okay. Heard Mr. S.A. Hussain, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Devojit Soikia, who has been detained behind the bars since 1/4/2024, within bracket for last 19 days, in connection with all women PS case number 19/2024, registered under section 354/354A1 within bracket small Roman 1 and small Roman 2 of Indian Penal Code. The gist of accusation against the present petitioner is that on where is the FIR?
As page number 15, Your Lordship. Dated 1/4/24, Your Lordship.
On 1/4/2024, the victim woman had lost an
May it please your lordship. While order dated 10/4, my learned friend was supposed to obtain instruction whether notice was served upon me or not.
So notice not served because my lord FIR lodged on 18/3 and he was arrested on 19/3 immediately, my lord.
What is the offense?
Offense, my lord. It under section, my lord, 120B, 406, 420, 468, 471.
What is the progress?
I'm on the
You
board,
were
madam.
arrested on 19-3.
19-3. 33 days in custody.
Heard Mr. S.M. Abdullah P. Learned counsel for the petitioner. Also heard Mr. Any objection?
I'm for the important document. I have objection of.
Foxo is there.
No, my lord, that's a case of my lord 468, actually, my lord.
Then you can only assess the PP. And PP, additional PP has submitted that notice under 41 was not. What is your objection?
At this instance, lots of investigation is going on there because one more person is victim in this case, and they have collected some documents, Aadhaar card, PAN card.
But regarding investigation, public prosecutor would be knowing. Any other objection, whether threatening is there, that may be ground for objection for you.
He is inside.
Heard Mr. S.M. Abdullah P. Learned counsel for the petitioner. Also heard Mr. B.V. Gogoi, Learned additional public prosecutor, as well as Mr. F. Hawk, Learned counsel for the informant, who is assisting the Learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Muhammad Abdul Malik, who has been detained behind the bars since 19/3/2024, within bracket for last 33 days. Is it 33 days?
33 days, madam. In my calculation, 33. 33.
You have manually calculated or by
No,
using
I-
a
I-
calculator?
Calendar, I am calculating inside the code, 33 days, madam.
Okay.
But I was weak in math, madam, but.
Actually, 30, it should be 32.
No, no, 30.
At one day, you have to deduct.
No, put a date over, date over.
That is, I understood.
Date over, date over. Okay, what? 19 तारीख को actually 18 तारीख को
What was the last name?
To count.
In connection with Nagaon
Already
case,
count.
case number 2331/2024. Under section 120B/406/420/468/471 of the Indian Penal Code. The gist of accusation in this case is that on on 18/3/2024, one Shariful Islam had lodged an FIR before the Superintendent of Police, Nagaon, naming the present petitioner, against the present petitioner, and one HDB Finance as accused, inter alia, alleging that the petitioner had lured the first informant by telling them that he would provide financial assistance from government scheme to the first informant, and on that pretext, what is the allegation?
Madam, on that pretext, he has collected some documents and obtained loan.
He has collected the personal documents of the informant and obtained loan in the name of the informant. However, the loan in the name of the informant for purchasing two-wheeler vehicle. However, neither the loan amount was provided to the petitioner nor the vehicle has been provided to the vehicle, and it is alleged that the petitioner in conspiracy with HDB Financial Service Limited has siphoned off money of the first informant and similarly other situated persons. Learned counsel for the petitioner has submitted that on the basis of the FIR lodged by the first informant Shariful Islam, Nagaon PS case number 231/2024 was registered under section 120B/406/420/468/471 of the Indian Penal Code. It is submitted by learned counsel for the petitioner that for the offences against which the case has been registered, the maximum punishment is not more than 7 years. Therefore, there is a mandate of issuance of notice under section 41A of the Code of Criminal Procedure in this case. However, no such notice was issued to the present petitioner, and he was arrested without following the mandate of the Apex Court in the case of Anesh Kumar versus State of Bihar. What is the citation?
I have cited Satyendra Kumar Until versus CBI, paragraph 5.
What is the citation?
Satyendra Kumar Until versus CBI, and another reported in 2022, 10 SEC 51. Paragraph 5, madam.
No. Learned counsel for the petitioner has also submitted that otherwise also the petitioner has already been detained behind the bar since 19/3/2024, and considering the period of detention, he may be allowed to go. Though the learned additional public prosecutor has opposed the grant of bail to the present petitioner. However, considering the fact that no notice under section 41A was issued to the present petitioner, and under the facts and circumstances of this case, notice ought to have been issued. Notice under section 41A of the Code of Criminal Procedure 1973 ought to have been issued to the present petitioner. Further, considering the progress made in the investigation and period of detention already undergone, this court is of considered opinion that further custodial detention of the present petitioner may not be necessary for fair completion of the investigation of Nagaon PS case number 231/2024 if he cooperates in the investigation. So, in view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to satisfaction of learned Chief Judicial Magistrate Nagaon with following conditions. Send by request.
Wait, please, your lordship. So this is a 439 application, lordship. The FIR is at page 7, lordship. Here is the informant, lordship, who happens to be the doctor, lodged an FIR against the petitioner by stating that the petitioner practicing medical, petitioner is a medical practitioner, lordship, without possessing any elite qualification, lordship. And the facts which came to the knowledge of the informant was that the petitioner issued some certificate and which has some spelling mistake about the disease, lordship. And after
Where
that,
is the FIR?
FIR is at page 7, Lordship, is a
It is a long FIR.
long FIR, Lordship. Here, the main allegation is that the petitioner, without having the valid qualification, Lordship, practicing
Since when you are in jail?
6/3/2024, Lordship. He has been in
40
custody for
45
45
days.
days, Lordship, as on today. And here, in this case, Lordship, the mandatory provision of section 41A has not been followed, Lordship. And it is reflected from the forwarding report itself, Lordship.
Where is the forwarding?
Report page 11, Lordship. Here is a type copy. 14 is the forwarding report. Ground of arrest. Ground 7. The arrested accused person may abscond if notice under section 41A is served against him.
So reason has been mentioned. But whether that has been, what the learned magistrate has.
He is a
Yes,
petitioner is a 68 years old person, Lordship, and he has been in custody for 60,
No, who,
45 days.
who are you now? Are you a doctor?
Lordship, he has some certificate, Lordship, and he can practice in a limited.
What
purpose.
certificate?
Certificate, Lordship, is a from the Central Council of Allopathic and Ayurvedic Practitioners. He obtained it in the year 1982, Lordship. And at that time, perhaps it was allowed, Lordship, and he practiced as a, like nowadays, rural health worker, Lordship. He prescribed saline, Lordship, and medicine for minor disease, Lordship.
Where is this Central Council of Allopathic and Ayurvedic?
It is reflected in New Delhi, Lordship.
This appears to be fake. Yes. Okay,
Yes,
30,
my lord, that
45 days.
alternative
What is
system
the
of medicine, my lord, he has a certificate. Alternative system of medicine.
where is the certificate?
That is, he has, my friend also annexed in the diary, it is there, my lord, the police collected.
Page 15 is that alternative medicine.
No, but you are not referring to that certificate.
Page 15 and 16. I have that.
Alternative medicine, okay.
Yes.
Okay. But this. Now, what is the investigation?
My lord,
No, keep the diary with you.
no, yes, my lord, because his statement, my lord, 161 statement, he is saying that,
And whether IO has verified the
no,
veracity of
that
his
is, that
certificate.
note is not there, my lord. Only that seizure is there, my lord, that is, she is, my lord, the certificate. But this may be true, but my lord, he issued death certificate of some person. So whether he is authorized or not, my lord, to issue death certificate. That is the case, my lord.
Heard. Mr. B. Halder, learned counsel for the petitioner. Also, heard Mr. B. B. Gogoi, learned additional of the prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Premananda Roy, who has been detained behind the bars since 6/3/2024 in connection with dispute PS case number 95/2024 under section 419/466/468/471/474/308 of the Indian Penal Code. The gist of accusation in this case is that on 18/12/2023, one Dr. Abhijit Neog had lodged an FIR before the officer in charge of Patashi Lambari Police Station, inter alia, alleging that the present petitioner has been practicing as a medical practitioner without having any valid license to do so. On receipt of the said FIR, Patasi number EPS case number 241/24 was registered. Learned counsel for the petitioner has submitted that the petitioner has been
Initially, Lordship, it was registered in Patasil police station, subsequently transferred to Dispur police station, Lordship. And I am seeking bail in Dispur PS case number 95/2024.
Stop. It is it registered as Patasi number. Later on, the same was said case was transferred to Dispur police station, and a fresh case, that is Dispur PS case number 95/2024 was registered. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since for last 45 days, and he is the holder of a certificate of registration to practice alternative medicine. Stop. Learned counsel for the learned additional public prosecutor has produced the case diary of Dispur PS case number 95/2024 and has submitted that what is the progress?
Progress, my lord, that those certificates is, my lord, investigation is progress, my lord.
That the investigation is fairly progressing. Stop. Considering the fact that the petitioner has been detained behind the bars for 45 days and the maximum period of detention and from the materials available on record, it appears that his custodial detention may not be necessary if he otherwise cooperates in the investigation. Hence, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to satisfaction of learned Chief Judicial Magistrate,
Kamrup Metro.
Kamrup Metro, with following conditions. Condition number 1. With above observation, this bail application is hereby dismissed.
Obliged.
Item 49 from supplementary.
May it please your Lordship.
Yes. Yes.
This is the case from yesterday. My lord was pleased to direct the PP to try it if the case diary could be made available. Perhaps the case diary has not come back.
Very
What happened, my lord, that diary was laying in the CGM court, my lord. Today, CGM court is, my lord, holiday.
But this is a case under the Assam Cattle Preservation Act, my lord.
You are the owner.
I am the driver, my lord. I was caught with the cattle, my lord. I was transporting 11 numbers of cattle, my lord. Everything is admitted, my lord. I was the driver. Now I've been in jail for 27 days, my lord. Cattle has been seized. The vehicle has already been seized, my lord. So perhaps detention will not be required, my lord. Already 27 days.
Yes. Considering the period of detention. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived. On the other hand, learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars 24/3/2024 within bracket for last 27 days. 27 days in connection with Khetri PS case number 42/2024. The said case was registered on the basis of an FIR.
Page 10, my lord.
FIR which was lodged by one one Kamal Bora of Khetri Police Station before the officer in charge of Khetri Police Station, inter alia, alleging that on 24/3/2024, the petitioner was apprehended while driving a Bolero pickup truck bearing registration number AS02DC3348, wherein he was transporting 11 numbers of cattle. And he could not produce any valid document for the said cattle. Learned counsel for the petitioner has admitted that he was apprehended along with the cattle. He has also submitted that the cattle as well as the vehicle has already been seized by the investigating officer. It is also submitted that the statement of the petitioner has also been recorded by the investigating officer. Further, learned counsel submits that considering the period of detention already undergone and considering the fact that the seizure of vehicle and cattle has already been made, his custodial detention may not be necessary. Hence, he has prayed for allowing the petitioner to go on bail. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record. Considering the nature of the case as well as the admission by the learned counsel for the petitioner that the cattle and the vehicle which the petitioner was driving have already been seized by the investigating officer, and his statement has already been recorded by the investigating officer. And also considering the period of detention already undergone, his further custodial detention does not appear to be necessary for fair completion of the investigation of Khetri PS case number
42 of 24.
42 of 24. In view of above, Khetri falls within.
Kamrup Metro, my lord. CZM Kamrup.
In view of above, the above named petitioner is in view of above, the petitioner, namely Nazrul Islam, is hereby allowed to go on bail of ₹30,000 with one surety of like amount, subject to satisfaction of learned Chief Judicial Magistrate Kamrup Metro, with following conditions, number 1 and 2. With above observation, this bail application is hereby disposed.
I'm deeply obliged, ma'am.
CD was probably CD is not there, madam. I'm not in interim, madam.
Months,
28.
that diary no.
On the
Next
FI
week,
is
any
at page
day.
13, madam.
What is the offense?
Offense is yes, 498A, 325, 315, 380.
498A.
Kindly see the FI, madam.
325 is also there.
It is against my not accused number 2, madam. The husband of the petitioner, madam.
You are?
But the petition number 1 is the murder of the madam. Accused number 2, petition number 2, madam. Accused petition number 2 is the husband of the informant. 3 is the madam uncle of the accused petition number 2, madam. And 4 is the madam brother-in-law of the informant, madam. Now, if you go by the madam FI, madam, at page 13, madam.
Today diary not received, my lord.
But I am not seeking any interim bail for the accused number 2, my husband, madam, as of today, madam. Kindly see for the whether madam bail can be granted. to the
We have
other
contact with my lord IO. Next week, any date, my lord, that may be fixed.
Oh, otherwise also 41A notice. No, 325 is there.
315 is there, madam. Miscuse of. Okay, Abhi, madam.
Let us see let us give one day. Heard Mr.
Yes, madam.
S. Bhattakur, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, same is not available. And he prays for some more time for producing the case diary. The prayer is allowed. Let
24, my lord, 24.
Let this case be listed again, not 24.
Bless.
Become a prayer.
I have received the instruction.
You require him.
Yes, that instruction I have received. His custodial detention is required. I can do it.
Lordship, may I submit?
Yes, yes.
The
No,
reference
just
is
I got-
to Peru-
But this case is an old case.
Mileage, yes.
He retired from service from,
Not retirement, dismissed.
dismissed from service on 21/9/2021. Lordship, another fact, on 18th, the investigating officer visited the house of the petitioner. And Lordship may please to see. Charge sheet has been, inventory has been given to me. All documents have been, even the earrings, necklace, Mangal Sutra of my wife also be seized.
okay, no.
Even Mangal Sutra was. It is not so legible. It is running 5 pages. All documents relating to property, LIC, policies, land of even my papers relating to sale of my cars were also taken away, including one necklace, 4 pieces of earrings. Even Mangal Sutra was also taken.
Now, what do you want to say?
And Lordship,
It is not an illegal, it is seized. Seized, my lord, as per
Yes.
law.
No, why are you making, you want to emphasize some point?
no, Lordship, because this is a disproportionate case. They said that they have made inquiry. Then what is the necessity of seizing all these materials? And Lordship, I am relying on judgment of Supreme Court. I am reading on, it's a small judgment. In this case, what happened? There was a police officer of Chhattisgarh. There was a case against him of disproportionate assets. He was released by the High Court on bail. The state came for cancellation of bail. In paragraph 5, Supreme Court says, we find that the present petition is nothing but a totally unwarranted exercise on behalf of the petitioner state. While considering the application for bail, the status of the applicant is not to be considered. As an ordinary citizen is entitled to his right under Constitution. Equally, a high-ranking officer cannot be denied right under the Constitution. Now it is important. In a case of disproportionate assets, most of the evidence is a documentary evidence, and therefore there is no question of tempering such evidence. more so when installation condition is imposed by the. So my point before you lordship, the matter is related to disproportionate assets. And
This case is registered under sections
13.2,
13.2 only.
yes, 13.1B and 2. 13.2. At this stage, I cannot dispute, but regarding lordship, the main allegation in the FIR is that I have accumulated property, they have assessed the property through one chartered accountant. And come to a conclusion that I have accumulated property 178%, more than 178%, I have accumulated the property.
Where is the FIR?
Lordship, FIR is at page 360, it start from 365. Lordship, main complaint is start from page 367. It starts from page 367. The entire complaint was initiated on the basis of anonymous complaint lordship. Under CBC guideline, that cannot be. That is a different aspect of the matter. Lordship, may come to paragraph 11. Page 368. Better lordship, maybe read paragraph 10 also. During the inquiry, it is revealed that during the check period from 1/4/2012 to 31/8/2020, the suspect officer Santosh Kumar Chaudhary possesses both movable and immovable worth rupees 54,34,880 at the end of the check period against his income rupees 1,33,33,457. Whereas his expenditure during the check period between 3,12,18,000 so and so. After computation of his income, assess and expenditure, final position of disproportionate asset is worked as under. Then lordship, they come to the percentage of DA with reference to income is 174.80%. No, rest lordship trial will take place. At this stage, although there are many points which we can dispute with regard to calculation of my assets. But this is not
No,
appropriate
you
for.
would require his presence only.
My lord, yes, because my lord, why custodial isn't necessary, my lord? The judgment which was placed before lordships. That judgment is, my lord, initially he was granted bail by the High Court and the government has filed an appeal before the Supreme Court, cancellation is bail. And now, my lord, that case was, he was arrested and charge sheet was filed. But here in this case, it's an investigation stage, my lord. That's why, my lord, this case is not, my lord, applicable in this case, my lord. Moreover, my lord, they say that, my lord, the Mangalsutra and all that was his, my lord, is a procedure, my lord, because a case of disproportionate assets, my lord. How he accumulate all these things, that's why, my lord, all these things are, my lord, seized, and this seize is not an illegal, my lord. As per law, it was seized. My lord, what is the
No,
question?
when you have made seizure of the properties,
My lord,
if he appears before you,
my lord. But since, my lord, the registration of the FIR is never, my lord, they appear before the IO, neither he cooperated in investigation, he was cleared away, my lord.
Lordship, that is absolutely incorrect.
My
I'm
lord,
disputing the submission of my landed.
my lord, because this is the instruction, I am not saying anything from the air, my lord. The instruction which was received from the IO, my lord. Yesterday also I speak with the, my lord, SP, he said, my lord, the SP says, my lord, he never, my lord, visited the SP office. Many occasions he was
no,
called.
whether any notice was issued. for
My lord,
appearance.
till date, my lord,
Because 13(1), what is the punishment? It is 7 years only.
no, my lord, up to 10 years.
10 years.
Yes, up to
After
10 years.
amendment.
That's why, my lord, 41A notice is not
Not
required.
applicable.
But everything is, I'm not disputing everything, anything lordship. But in case of disproportionate asset, see what is the law? Check period is from 2010 to 2020. They have made calculation, everything has been, preliminary inquiry is held, property was seized. And lordship, subsequent seizure, whether it is in case of this type of nature, whether subsequent seizure is at all required. Although we are not challenging that at this stage. Our main contention is that everything is before the authority lordship. And they have made calculation, on what basis they made calculation lordship? If the authority has no document with them, how is it?
No, Why you require his custodial detention?
Because my lord, we need my lord, how he accumulated such type of disproportionate assets. And my lord, at the time of when he was in my lord, the police. And he used his, my lord, misuse his official power and my lord collected all that, my lord, the assets.
He
Which
was
was my,
dismissed for having disproportionate asset, no, for some other. purpose.
For unauthorized absence before the in my duty law.
Because
That was the ground.
when he came to know that my lord, all this is came upon and revealed from the my lord investigation officer, my lord, they tried to evade from the all investigations and all my lord. Even he, my lord, not even join his duty also, my lord.
Lordship, these are the three orders, where three cases, well, on last occasion, my learned friend submitted that another case has been lodged against me. In one case, I was granted indemnity bail, one case stays operating till date, Lordship.
And the checklist also, my lord, in the instruction is there, my lord, why is custodial detention is necessary. That checklist also, my lord, provided by the IO.
Where is the checklist?
It is, my lord, in our instruction, my lord. At, my lord, why custodial detention is necessary in 1, 2, 3, 4, 9 para is there, my lord. It is elaborately written by the IO. Why is custodial, then checklist, my lord, Lordship may got it. As per the Anesh Kumar, as per the direction of Honorable Supreme Court in the matter of Anesh Kumar, this checklist was prepared. Why is
You know, you
custodial?
are saying Anish Kumar is not applicable.
No, my lord, the condition, the preparations, my lord. Anesh Kumar is, my lord, Anesh Kumar is not only for 41 in notice, my lord. The other guidelines is also there, my lord, in the Satindra until also, my lord. These are the checklists prepared by the as per Honorable Supreme Court order. 18 grounds, my lord.
Ground number 1,
Yes, my lord. Whether the arrest is necessary to prevent the accused from committing any further offense, yes. Whether the
How?
accused,
how? He is now dismissed from service.
my lord, not only the dismissing from service, my lord, because suppose a person's, my lord, for example, a
Whether-
person's,
Whether he is involved in some other offenses also,
yes, that's why my lord,
Apart-
the other cases was registered, my lord.
apart from
Yes,
disproportion.
that Pokrajar PS case is there. No doubt, bail is his right, my lord. He got bail from the interim bail and he filed in quashing petition that stay was, it is the procedure of the court, my lord. But he is a habitual offender, my lord, not only this case, my lord. And he is misuse his power, my lord, because he was in earlier occasion, my lord, he was in before that dismissal from service, he was in police, he know everything, my lord. How to, my
But
lord,
now he is powerless.
no, my lord, no doubt he's powerless, but his connections, he's connected the people's, my lord, his influence, he's an influential person, my lord, still he has that influence, my lord. So in this regard, Supreme Court also said, that's why, my lord, this is the, my lord, the order passed by this Honorable High Court regarding Nonokali Hazarika, my lord. This is also a case of, my lord, disproportionate assets, my lord, where he was searched, he was in jail. Thereafter also, my lord, this Honorable Court rejected his bail applications many occasions. And these are the orders, my lord, which I have been appeared, my lord, and it is a socio-economic offense also, my lord. Because that was also discussed in this order, my lord. And the influential persons, how influential person, not only, my lord, the politically, financially, or the muscle power, everything it was written in the said order, my lord. And then socio-economic offenses treated in a class apart, it cannot be treated as in like general offenses, my lord. It was also discussed, my lord. This is the order of our High Court, where, my lord, the Ronokali Hazarika, this proposal cases, asset is there. His charge sheet was filed. Thereafter, his bail application also was rejected.
Lordship, he was in the office at the relevant time.
No, my lord, when the order was passed, my lord, the officer nothing. He was, my lord, dismissed. Here he is a police officer at the point of time. He was not in office, my lord, when this bail application was rejected.
As far I know, he didn't cooperate with the investigation also.
Here also same, my lord, he also not cooperated in investigation.
Lordship, please to see the records. Then
Yes,
if I have
this
not
record is there, my
cooperated-
lord.
No,
Record
if
is-
I have not cooperated, Lordship, for just for argument's sake, then how they collected this information? And the day before yesterday, they visited my house, they have seized as many as 24 items. And Lordship, I have not understand one thing. The earrings, necklace and Mangal Sutra of my was also taken, seized by them. This is the conduct of the prosecution agency. Lordship.
Then, my lord, police cannot seize anything, my lord, na car, property, nothing will be seized, my lord.
I'm not saying with other seizures, Lordship. Whether my Mangal Sutra is necessary to be seized. And it is a precious and religious thing of a woman.
No,
Lordship.
the question before this court is whether your presence is necessary.
That's it, Lordship, I am ready to cooperate. Any condition may be, every day I will be appear before the IO.
Paragraph 8, your lordship may see in the IO instruction, my lord. In connection in the instant case, he was directed to remain present at his residence during the time of assessment and valuation of his property by MPLN government register valuer on 8/4/2014 at 11 AM. This refer memo such and such dated, but he did not cooperate with the investigation and did not remain present during the assessment that was conducted on 18/4/2024 at 11 AM and sent his wife to Srimati Saraswati Chaudhary at the residence of Rajaduar, North Guwahati. Even his wife denied to know about his present whereabouts. The custodial detentions of the petitioner is necessary to prevent significant risks of the potential destruction of or tampering the crucial evidence. Additionally, there is a substantial likelihood that the individual, if granted pre-arrest bail, may exert influence on persons acquainted with the fact of the case, thereby compromising the integrity of the ongoing investigation. Means, my lord, the entire thing has not been, my lord, still today, my lord, because investigation is still going on. There may be possibility, my lord, the collected some more evidence. So at this stage, if he is allowed to go on bail, there may possibility, my lord, he is restrict the evidence and it will hamper the, my lord, the investigation. For the interest of justice, your lordship may at this stage not be allowed to go in bail, my lord, because his custodial detention is necessary, my lord. For proper investigation, for the interest of the investigations, my lord.
Lordship,
Because he is a powerful person, my lord. No doubt, he is not in service, but his influence, his connections with the other accused, co-accused, probably. Because investigation is still going. We cannot say that investigation is complete. Yes, investigation is
No,
complete.
disproportionate asset, where is the question of co-accused?
No, my lord. I am not saying, my lord, co-accused. My lord, yes, there may be some co-accused because when the investigation, how he collected from the, probably, my lord, the assets, he cannot be, my lord, collected from the innocent person. Probably he may some other person who can help him to get these said assets, my lord. That may be possibility because
Yes,
we
yes,
cannot
no,
say at
no,
this
but-
stage.
But the offense is, if you possess assets disproportionate to your income, that in itself is an offense.
yes,
So if you are having disproportionate asset.
Probably, my lord, see.
disproportionate to your income, that is an offense.
There may be
Yes,
some
for that-
abettors, my lord. There may be some abettors. It will come, my lord, 120B. Section 12 of the PC Act is also there, my lord. In many cases, I have seen, my lord, disproportionate asset case. Later on, when investigations was, my lord, conducted, later on came to know that some co-accusers also there, my lord. They are treated to be abettor and
Okay,
120B.
You have any more submissions?
yes, Lordship, we come to page 25. My
Not
learned
now,
friend,
at two.
no, learned my friend says that I have not cooperated.
During research, I will go through the case.
Lordship, go through page 25, 24 to 364. All this information was provided to me in the year 2022 itself. All the documents, everything. And Lordship, please to note, what is the check period?
2012 to 2020.
2020. And they've already assessed through one chartered accountant also. Lordship. Then how they come to know that my disproportionate asset is 178%?
It was done by the government valuer, not by us, not by the investigating officer. My lord. The government valuer is there, their assessment, and thereafter they, probably it may be more, my lord. After, my lord, the investigation is revealed more, my lord, then it may be extended, my lord. Cannot, at this stage, cannot say, my lord, this is the exact amount, my lord.
At two, I will dictate your.
Much of that.
You go through the judgment after some time.
Yep. I'm deeply okay.
See, before Lordship, I want to place the provision, section 13(3),
Yes.
explanation 1. Section 13 of PC Act laws. Because FIR is set under section 13, 1B and 2. What's going to place? Explanation 1 to section 13 laws.
Yes, explanation.
A person shall be presumed to have intentionally enriched himself illicitly if he or any person on his behalf is in possession of or has at any time during the period of his office. During the period of his office, and here lordship, the check period is from 2012 to 2020. But the argument say, if at present they have searched my house, if anything is found, that cannot be included. This is my argument.
That lordship, the argument which was laid,
You cited a judgment also.
Yes, lordship.
Where is that judgment? Which was Allahabad High Court.
Paragraph 5, and there is a Supreme Court judgment. In that case, lordship, in paragraph 5, it said that we find that the present petition is nothing but a totally unwarranted exercise of his.
What is the citation?
Lordship, it is reported in Supreme to 2022 0 Supreme SC page 157. That is, I am relying on paragraph 5 only. Although facts are some different in this case or this case, lordship. But lordship, Honorable Supreme Court says that in case of disproportionate assets, most of the evidence is documentary evidence, and therefore there is no question of tempering such evidence. And moreover, I have already dismissed from service in 2021. And check period is, lordship, please to note, check period,
That ruling,
lordship, 2022
2022.
0 Supreme
Supreme.
SC page 1527. Number of the cases specially to appeal criminal.
The name of the party.
Name of the party is State of Chhattisgarh versus Gurjinder Pal Singh. I'll supply copy to court master through email also. Paragraph 5, already on
When will you supply?
today itself, within 5 minutes. I'll mail to the.
He was
court master.
arrested.
Then I cannot dictate the order now.
Court master may reserve the order. May pronounce on mail.
my lord, this order is not applicable in our case, because in that case, my lord, he was arrested and
Then
searches has been
yes.
completed, investigation is completed, that's why I said there is no, my lord, the tampering or hampering of documents is all documented, but here investigation is still going on, my.
High Court of Chhattisgarh, they are going to go on bail. Thereafter, the state of the state, we filed an application. The petition
Lordship,
should be
may please to see again that's FIR lots, what it contains. I have understood the anxiety of my learned friend, lordship.
It is not a question of anxiety, you know, sir. It is our duty to assist the court, you know, say. Question of anxiety, and these are the, my lord, submission is not, my lord, the acceptable in this court, my lord. It is our duty, I am assisting the court. I am not the authority, my lord, rejecting and allowing the bail, my lord.
In the first half, Mr. Kyle was in your role.
Yes, my lord. Because my
Lordship,
duty is
as a
an
counsel-
officer of the court, your lordship, I am
Lordship,
assisting.
As a
you.
council, lordship, we have to play a different role at a different time.
Now anxiety is, my lord, my learned
So
friend,
you
my lord.
don't have to be anxious. Anxiety has no place.
No, lordship.
Yes.
No, here, lordship, the case is of BA under section 13, FIR registered. And explanation to section 13(1)A says that when is in office. And suppose, lordship, just for argument, I have accumulated property after my dismissal from service, whether that can be accounted for.
Where is the affair?
FIR is page 367, lordship.
Heard Mr. SCKL, learned counsel for the petitioner. Also heard Mr. M. Fukon, learned public prosecutor, state of Assam. This application under section 438 of the Code of Criminal Procedure Common 1973 has been filed by the petitioner, namely Santosh Kumar Chaudhary, who is apprehending his arrest in connection with CM Vigilance PS case number 4/2024 under section 13 within bracket 1 within bracket small b /13 within bracket 2 of the Prevention of Corruption Act 1988. The accusation against the present petitioner is that, where is the FIR?
Page 367. It will start from 364, but
That the present petitioner was serving as what?
ESI Lord. ESI.
Ass- Assistant Sub Inspector of Police. Where you were posted?
Lordship, Lordship, page 67, paragraph 2. During the inquiry, it was found that Sri Santosh Kumar Chaudhary was appointed as
Was,
AP constable.
yes. Was, the present petitioner was appointed as an AB constable in 6th APBN in the year 1999. And later on, he was transferred and posted to first APTFBN Dakur Vita, Gwalpara on 18/3/2005 on promotion as ASI/SCRIMO. On 2/4/2024, one Vijit Dadhara, Inspector of Police, CM's Special Vigilance Cell, Assam, has filed an FIR before the officer in charge of CM Vigilance, CM Special Vigilance Cell, Assam, inter alia, alleging that on the basis of a complaint received from one Partho Gogoi, to the effect that the present petitioner has been collecting money from government employees by falsely intimidating them and that by this process he has accrued huge properties in Guwahati and Bihar and owns 8 numbers of vehicle and 1 motorcycle and also purchased landed properties, and inquiry was initiated, and during the inquiry it was found that the petitioner has accumulated disproportionate asset, and the percentage of disproportionate asset with reference to his income was found to be 174.89%. The check period for the inquiry was for the period 2012 to 2020.
2012 to
22. 2012 to 2020. 20. Learned counsel for the petitioner has submitted that the petitioner has already been dismissed from service on
21/9/2021.
on 21/9/2021, while he was posted at first APBN Dakur Vita. However, after filing of the, now why are you apprehending your arrest?
Lordship, my house has been searched, and earlier occasion also, when the case was started, I was given threatening by some of my colleagues.
However, after filing of the FIR, he is apprehending his arrest in connection with the what is the case? CM's vigilance, PS case number 4/2024. Learned, now what is your submission, learned counsel for the petitioner has also submitted that when you got notice from
On 16. No, no, that was on probably 16.
probably will not do.
I'm just. And on 18th, they visited my house and sees number of articles, including ornaments of my wife also. Not in date is 16/4.
Petitioner has received notice for search of his house from the investigating officer on 16/4. And accordingly, he allowed his wife to remain present. And the search was accordingly conducted in his house situated at
Rajadwar and Rajadwar North Guwahati.
at Rajadwar, North Guwahati. And
rented house at Bhangagarh.
and at a rented house at Bhangaghar. And several articles were seized therefrom, including the ornaments of his wife. Learned counsel for the petitioner has also submitted that earlier. No, you submitted that in 2022, you cooperated.
Yes,
But at
I
that
have
time-
submitted annexure 3. All the documents were submitted by me.
You cooperated in what proceeding?
Not RE.
Regular inquiry.
Yes, regularly. Page 24 only. Page 24. It's running from page 24 to 360, 363, 664.
Learned counsel for the petitioner has submitted that the petitioner has earlier had earlier cooperated in the regular inquiry on the basis of which the present FIR has been lodged. He has disclosed, it is submitted that he has disclosed all his statement of assets and liabilities during the regular inquiry. And he is also ready to cooperate with the investigating officer. It is further submitted that presently the petitioner being dismissed from service is not in a position of power and therefore not in a position to influence the investigation in any manner. It is also submitted by learned counsel for the petitioner that the case against petitioner has been registered only for the offense of disproportionate only for the offense of possessing possessing property disproportionate to his known sources of income, and that too for the period from 2012 to 2020. 2012 to 2020. It is submitted by learned counsel for the petitioner that the that in a case for disproportionate assets, the most of the evidence is in the nature of documentary evidence. And as the period for which the case has been lodged relates to 2012 to 2020, there is no possibility of tampering with the evidence which has already been collected by the investigating authority. As the present more so as the present FIR was lodged on the basis of regular inquiry which was conducted, during which all the relevant documents, all the relevant evidence was collected. In support of his submission, learned counsel for the petitioner has cited a ruling of the Apex Court of India in the case of State of Chhattisgarh versus Gurjinder Pal Singh, reported in 2022, 0 Supreme within bracket SC 1527. Any other submission? On the other hand, Mr. M. Fukon, learned public prosecutor, has vehemently opposed the grant of anticipatory bail to the present petitioner on the ground that though the petitioner has been dismissed from service way back in the year 2021, however, he was holding a position of power and he may have links with
The other high officials of the department.
other high officials of the police department.
Hmm.
And therefore, if he is not arrested, there is every possibility of his influencing the investigation. It is also submitted by learned public prosecutor that during the course of inquiry also, the petitioner was summoned on several occasions. However, he never turned up and cooperated in the inquiry. It is also submitted by learned counsel for learned public prosecutor that the present petitioner is a habitual offender and has other cases pending against him, namely Pokrajhar PS case number 132/2018 and Pokrajhar PS case number 224/2018. Do you have a passport?
Passport is there. We'll surrender also.
What, any other It is also submitted by learned public prosecutor that during the search of his residence also, the petitioner did not cooperate and had sent his wife Saraswati Chaudhary at his residence at Rajadwar, and even his wife also denied about the denied about her knowledge regarding whereabouts of the present petitioner. It is submitted by learned public prosecutor that the custodial detention of the present petitioner is necessary to prevent the destruction and tampering of evidence. And hence, the prayer for anticipatory bail may be rejected. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary has not been.
Yes, I have received it.
And gone through the case diary of CM's Vigilance PS case number 4/2024. Where is the FIR? It's 167.
367.
36. There is no dispute at the bar that presently the petitioner is not in service. He has already been dismissed from service on which date?
21/9/2021.
21/9/2021. It also appears on perusal of the FIR that the check period for which the present petitioner is suspected to have amassed wealth beyond disproportionate to his known sources of income is from the period is from 1/4/2012 and 31/8/2020. It also appears that on on 18/4/2024, at the time of assessment and valuation of the properties of the present petitioner by empaneled government registered valuers, though the present petitioner was not available, he had sent his wife Saraswati Devi to remain present during the said assessment procedure, which indicates that he had cooperated in the investigation. Moreover, as the case, in a case of disproportionate assets, the evidence which is involved is mainly documentary evidence, and therefore, and as the period during which the offense of possessing disproportionate asset is alleged is much earlier, that is from 2012 to 2020. There is very unlikelihood that the petitioner who has already been dismissed from service would be able to influence would be able to tamper with the evidence which has already been collected during the regular inquiry. For aforesaid reasons, this court is of considered opinion if the petitioner cooperates in the investigation and makes himself available for interrogation before the investigating officer as and when required, his custodial detention may not be necessary for fair progress of the investigation of CM Vigilance Cell case number so and so. Therefore, for the reasons mentioned above, the petitioner is hereby directed to appear before the investigating officer of CM's Vigilance PS case number 4/2024 within how many days?
Within a week.
Within a week from the date of this order, and cooperate in investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with CM's Vigilance PS case number 4/2024, he shall be allowed to go on bail of rupees 50,000 with one surety of like amount, subject to following conditions. Number one, that he shall surrender his passport to the investigating officer of the aforesaid case and shall to the investigating officer of the aforesaid case. Any other condition which you want?
And my lord, the failing which that would also be included, and moreover, he should not leave the jurisdictions of the
Yes,
Kamrup.
that can.
Of Kamrup.
My lord, yes.
Kamrup is okay for you?
Yes, Lord. Yes, Lord.
Okay. The petitioner shall not leave the jurisdiction of Kamrup Metro District without prior leave from the investigating officer. Any other officer?
Lordship, his house is in rural, Kamrup rural. Lordship. I mean,
So let it be Assam.
My lord.
Let it be Assam instead of Kamrup. From the instead of Kamrup, state of Assam. If you leave Kamrup, you have to
yes, definitely.
inform.
He will be abide by all the condition, whatever condition is imposed by law.
Any other condition? He shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of this case, so as to dissuade such person from disclosing such facts before the investigating officer. Any violation of the condition imposed may be a good ground for cancellation of bail, anticipatory bail
Lots.
granted to the present.
Lots.
With above observation, this anticipatory bail application is hereby disposed of.
Much obliged.
Send back the consent.
Yes, Lordship, we have instruction. Earlier, my lord, GD entry was registered. Thereafter, both party came to the police station and they says that they amicably settled matter. This is the
There is no case.
no case.
None appears for petitioner on call. Learned additional public prosecutor has submitted that though a GD entry number 569 slash dated 17/8/2023 was made in connection with the allegation leveled in this case. However, later on, both the parties amicably settled the money, amicably settled the dispute, and therefore no case has been registered. In view of the report submitted by learned additional public prosecutor, this anticipatory bail has become infructuous and same is dismissed on becoming infructuous.
So I have gone through the LCR, Lordship. Here, Lordship, the LCR, but I have found it is the supplementary case record from the Chief Judicial Magistrate Court, Lordship. And I have flag mark also there, Lordship. There, so the CD and the other part are not available. It is before the learned session, just Lordship. And whenever regarding in the order, it reflects that many times the 67 notice was provided. That is also here not available. And the order, it is clearly stated that the original case record, it is with the session just, Lordship.
Okay.
Yes, Lordship. May kindly see the orders, Lordship. So
would
I
be
was
required,
unable to
Mr.
find it out, Lordship.
Mr. Datta,
My lord.
this would be required.
My lord, that's true, my lord, but the very prime issue, my lord, this honorable court, while it was heard
No,
by
to
another. court-
verify your submissions.
My lord.
To verify your submissions. That
Lord, sir,
no leave was taken for
Exactly.
case diary would be required. Case diary,
It was expected that they will produce it because the order of the court was that.
And even Lordship in the office note, that also I have gone through. In the office note, it was stated as the supplementary list. So from the learned court below, it was sent, Lordship.
no, since when you are behind the bar?
My lord,
2024.
since 3rd February. my lord.
2024.
I'll just highlight the conduct of the prosecution. Whether everything is fair. That's the thing I will take your lordships.
No, actually, supplementary case record was called for.
My lord, in fact, supplementary record is necessary because the leave will be there only. In the original record, it won't be there. Whether they have sought for leave or not, that will be there only. And my lord, I am 100% sure that application is not there. They did not make it.
Original leave was called for in the previous, first date,
On the
For
first date, my
case
lord,
date.
the original was called for.
23 to 24.
That is on
But
23.
leave has to be taken from the special judge,
My
not
lord,
from the CGM.
yes. No,
because
it won't be from the CJM, my lord, because the application will be filed before the special judge.
Special judge.
And obviously, there is no application because your lordship has seen the special judge himself directed the CGM to take the evidence under section 164. Therefore, there was no application before him. On that day also, I argued that before another court. And obviously, my lord, that application was not there. Wherefrom they will give it? My lord, your lordship kindly see then the conduct of the prosecution, your lordships see that they have said that your lordship kindly see on 6/7/2023. Then on 27/2023, I'm taking to my brief, my lord, at page 27. The lordship will find the order dated 6/7/2023. They are saying that we have flouted 67 notice, but there is no reflection to that effect in the charge sheet. And your lordship kindly see page 27.
Now let us call for the scan copy.
My lord, before that, I would like to take your lordships to very specific case on the point of whether leave is necessary or not. My lord, the appeals court has said
No, to
170.
verify that, that I have understood, that your.
No, no,
pen-
further improvement is there in the year 2013. Well, just a single line, I'll just read. It is no more, my lord, res integra. Law is well
that leave
decided.
is necessary.
Yes, yes, my lord, the appeals court has said is like this.
So we have to verify whether leave was taken or not.
Well, that's true, my lord, but I wonder what they are doing so long. My lord, it's an illegal detention. Can they play with the life of a person? It's a liberty of a person. Article 21 is violated. And the learned
No,
special judge
actually-
also.
Actually, the record shows that only supplementary case record of Bajari Chera PS case number was called for. While the,
My lord, your lordship kindly see 23/2/2024.
these orders are passed in special NDPS case number 70/2020.
Yes,
So the record of special NDPS case would be required,
Yes,
along
Lord.
with the scan copy of the case.
yes,
diary.
can copy lordship.
call
Then
for
we
the,
will be in a position to appreciate your submissions.
my lord, your lordship kindly see, call for the case diary in connection
may
with
have a
special
good
NDPS.
case. If it is ultimately found that no leave was obtained, but to verify, we need records. What is that judgment, latest judgment?
Yes, letter judge, it will be there. There's a more beautifully placed, my lord, in the richest time I went through it. It's a wonderful decision. my lord. As if, my lord, as the lordship has seen, 173(8), no language was inserted to that effect. But appeals court has said, by the time it has been accepted as a part of that 173(8). Your lordship may see para 49.
2013. 5 SCC 762. Yes. Para?
Para 49. Your lordship got it.
Yes.
Now we may examine another significant aspect, which is how the provision of section 173(8) have been understood and applied by the courts and investigating agencies. It is true that though there is no specific requirement in the provision of 173(8) to conduct further investigation or file supplementary report with the leave of the court, the investigating agencies have not only understood but also adopted it as a legal practice to seek permission of the courts to conduct further investigation and file supplementary report with the leave of the court. The courts in some of the decisions have also taken a similar view. The requirement of seeking prior leave of the court to conduct further investigation and or to file a supplementary report will have to be read into and is necessary implication of the provision of section 173(8) of the code. So, my lord, the law is very well demarcated that it will have to be read along with section 173(8).
Okay. Third, Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, learned counsel for the petitioner. Also had Mr. K. Bosho, learned additional public prosecutor. Learned counsel for the learned senior counsel for the petitioner has submitted that the petitioner is the owner of the vehicle bearing registration number. You verify, correct me. What is the registration?
Ma'am,
number?
WB,
WB 29B 5386.
correct.
Which was seized in connection with Bajari Chera PS case number 126/2023. And the petitioner, you were not named in the FIR.
I mean, the name in the FIR, but not charge sheet.
And though the petitioner was named in the FIR, however, when the charge sheet was laid, he was shown as an accused, not charge sheeted. Learned counsel for the petitioner has therefore submitted that from records, it may be implied that no evidence was found against the present petitioner, and therefore he was not charge sheeted in spite of the fact that he was named in the FIR. Learned senior counsel for the petitioner has further submitted that, however, on 3rd of February 2024, when the petitioner went to take the Jimma of the seized vehicle to the police station, Bajari Chera police station, he was arrested. It is also submitted by learned counsel for the petition, senior counsel for the petitioner, that once charge sheet has been laid showing the present petitioner as not charge sheeted accused, he could not have been arrested without initiating further investigation and collecting materials to justify his arrest. However, in the instant case, it is submitted that it is further submitted that it is no res integra that for initiating further investigation after submission of charge sheet, leave of the court is necessary. To substantiate his submission, learned senior counsel has cited a ruling of the apex court in the case of Vinay Tyagi versus Irshad Ali alias Deepak and others, reported in 2013, 5 SCC 762, wherein the apex court has observed that, within inverted comma, the requirement of seeking prior leave of the court to conduct further investigation and / or to file a supplementary report will have to be read into, comma, and is a necessary implication of the provisions of section 173 within bracket 8 of the code, inverted comma close. Learned senior counsel submits that the record shows that no such leave was obtained by the investigating officer, and it is only after arrest of the present petitioner the investigating officer made a prayer for recording statement of 2 witnesses under section 164 CRPC, which was allowed by learned Special Judge Karimganj by order dated 5/2/2024. Stop. Learned senior counsel for the petitioner submits that the learned special judge also acted beyond her jurisdiction by allowing the recording of statement of the witnesses under 164 CRPC without the investigating officer seeking prior leave to conduct further investigation in this case. Stop. On the other hand, learned additional public prosecutor has submitted that only the scan copy of Bajari Chera PS case number 126/2023 has been called for in this case. However, considering the submissions made by learned senior counsel for the petitioner, perusal of the case diary of Bajari Chera PS case number 126/2023, as well as case record of special NDPS case number 70/2023 would be necessary. So, though learned senior counsel has raised a very crucial point. However, to appreciate the submissions made by learned senior counsel for the petitioner, perusal of the case record of special NDPS case number 70, as well as case diary of Bajari Chera PS case number 126/2023 would be necessary. Hence, comma, the registry is hereby directed to issue requisition for obtaining the scan copy of the case diary of Bajari Chera PS case number 126/2023, as well as scan copy of the entire case record of special NDPS case number 70/2023 from the Court of Learned Special Judge Karimganj. When
Your Lordship, next week, Lordship is available
after 6th,
after 6th.
let this data. Let this case be listed again on 9th of May for the case records. The registry shall ensure the production of, ensure that steps for obtaining the aforesaid scan copy is taken well ahead in time, so as well ahead in time. Stop. List this case again on 9th of,
As part of,
part of.
much of. My Lord, with all humility, what I can say, that this order was passed way back on 23/2, but then I don't know why they are saying that this special NDPS case number 70 of 23 was never called. That statement is not correct. If your Lordship look at 23/2/2024, specifically it was
23?
23/2/2024.
Oh, yes.
But Lordship, in the office note, what I have found is there is the supplementary part is there. And from the record
No, yes,
also.
it was called for,
Yes.
but I'll make necessary corrections in the order.
Well.
But therefore it is required.
Obviously.
In case below.
Therefore, my Lord, I hope they will try their best to bring it. by
No,
that
it is from the scan code.
No, I have
Registry.
issued
Registry, Lord.
directions to registry. Registry
Yes.
will ensure.
My Lord. Much obliged.
Made this Lordship, bail application on the 439. And today I would like to take the ground of parity, Lordship.
Parity.
Lordship. The co-accused already been enlarged on bail. Now I was arrested on the basis of the confessional statement, Lordship.
You were arrested on?
They arrested on, my lord, arrested on 1st of October 2023.
What is your name?
Abdul Razak Shah. I was with Lilakanto Soikia, and the Lilakanto Soikia has already been allowed to go on bail.
No, cases of, in NDPS case, parity will not.
Parity
have to-
will not come.
You have to argue your own case, where you stand,
Lordship, yeah. Lordship, actually,
because allegations is that you,
this comes under the intermediate quantity, Lordship.
intermediate.
Lordship, 250 grams, Lordship. 250 grams.
Okay,
Lordship,
that may be a submission.
Lordship. Lordship,
What is a seizure?
Caesar, just a second. Caesar is my heroine, man. It is heroine now, not. At first, I suspected, now it is heroine confirmed. Man.
No, but if it is 250 only, what
250
was
on-
the
250
quantity?
only, Lordship.
250 is
Which
the
the-
borderline.
Yes,
More
250 will
than
be my lord,
250 is
will be-
commercial.
250 will be commercial.
No, 250 will not be commercial.
More than 250. to be
More than
commercial.
250 will be commercial.
Below 250 would be intermediate. Under the my intermediate understanding that 250 will be
Let
commercial.
us read it.
Yes, regarding.
NDPS Act, take
Yes.
NDPS Act.
Lordship. My lord,
Where is the definition of commercial?
Yes.
Section 27A. Let us read it together.
Lordship, lordship.
Marketa. 27A.
Lordship. May I read, Lordship?
Yes.
Commercial quantity in relation to narcotic drugs and psychotropic substances means any quantity greater than the quantity specified by the central government by the notification in the
So it
official
is
gazette.
greater than the quantity specified by the notification. Now,
Yes.
what is the quantity mentioned in the notification?
It is 250, man.
So it has to be
It is
greater than
250.
250 to be commercial quantity. You have to explain me. I have to understand.
Yes, loss.
It is not other way around. So what,
Quantity specified by the central government. Yes, yes, quantity.
so if it is not
But-
a commercial quantity, then the
But my
embargo
lord,
of
what I am confused, my lord, regarding this, my lord, if your lordship may kindly take up the schedule, my lord,
yes,
in the NDPS. my lord. Lordship, I am in jail for 203 days.
no, if we read, new things may come up.
Lordship,
Yes. Schedule.
yes, lordship, if it is this book, my lord,
Yes.
it is
Serial
page,
number, serial number.
page 222, my lord.
56.
Yes.
Next.
Notification specifying, my lord,
Yes.
small quantity and commercial quantity. Now, my lord, in exercise of the powers conferred by clause such and such, section 2 of NDPS Act 1985, and in supersession of Ministry of Finance Department of Revenue notification number such and such dated July 1996, except as respects things done or omitted to be done before supersession, the central government hereby specifies the quantity mentioned in column 5 and 6 of the table below in relation to the narcotic drug or psychotropic substances mentioned in the corresponding entry in columns 2 to 4 of the said table as the small quantity and commercial quantity respectively for the purpose of said clauses of that section.
Central government hereby specifies the quantity mentioned in column 6. For the said clause.
Yes,
Said clause means clause 7A.
yes, as the
7A in the first line, yes, read. In the notification itself it mentions the clause 7A. Now 7A says that
has to be greater,
It has to be greater than the
Greater.
quantity mentioned.
Yes.
So
Yes.
if the central government notifies 250
Yes. Mm.
for being commercial quantity, it has to be greater than 250.
If we read conjointly,
We have to read because
yes,
statute will prevail over
yes,
notification.
yes, no.
Then how many days you are behind the bars?
203 days, Lordship.
How, Mr.
M. Rahman.
M.
Rahman.
Rahman, learned counsel for the petitioner. Also Mr. M.T. Goswami, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner. Namely Abdul Razak Shah, who is detained behind the bars since 1/10/2023 in connection with NDPS case number 4/2024 under section 21C/29 of the NDPS Act. The gist of accusation, Court Para 3 from bail application number 681/24. 681 dated 9/4/2024. Code Para 4. No, not Code Para 4. Instead of Para 4, on receipt of the aforesaid FIR, North Guwahati PS case number 116/2020. 2023 under section 21C/29 of the NDPS Act was registered. And during the course of investigation on 1/10/2023, the petitioner was also arrested. Code Para 5. There are 6. When charges were framed, there are 7.
Charges on matter 5
Fine.
to
There are 7,
2024.
there are 8,
5 to
there are 9, there are 10, there are 11, there are 12. With necessary changes. Well, the petitioner is allowed to go on bail of ₹50,000 with 2 sureties of like amount, subject to satisfaction of learned special judge.
highly up. Regarding the matter, has your lordships matter observed that it is a commercial or
Yes, I have made, because this similar order has been passed
yes,
in for the co-accused.
yes,
Co-accused took the same plea.
yes.
So I
yes.
have, you go through the
Yes,
order.
yes,
like
I
that.
have gone through, I've seen, can an observation be made, this is for the purpose of the bail, consideration of bail?
Yes.
Because it might
Yes,
affect.
last order, last. The observation made above are only for the purpose of consideration of the instant bail application. And it would not in any way affect the trial
Yes,
pending against the present petitioner.
deeply obliged. Yes. Highly obliged. Because now the charges are framed, they may do the work, matter. Now the charges are framed under 22C. So, they should now all come up for as per advice, whatever they have to do.
No, I am not getting.
No, the now charges are since framed, that is why.
Yes.
That is why now.
That is where,
That is their,
what they do,
that is what I am saying. It is their part now.
because charges can be altered also
Also, that
during
is,
the pendency of trial.
yes,
charges can be altered, modified also.
Yes.
OTR, my lord, 438 application. In IA, my lord, I am not placed, my lord, now. It is for, my lord, interim order, IA was filed, my lord. Maybe your lordship, maybe heard main case, my lord.
In interlocutory application, this IA is dismissed on not being pressed. This interlocutory application is dismissed on not being pressed.
Main case is, my lord, 438 application, my lord. FR is page 8, my lord. Dispute between my lord land, my lord.
Lordship, first, your lordship may kindly see the last order, my lord, 9/4/2024, my lord. And,
9/4, there is no order.
the previous order, my lord,
Or in the IA,
just
yes.
there is some direction to the petitioner, my lord.
This is my lord certified copy, my lord. But I have purchased the land, my lord.
Administration. What is this?
This is my lord sale deed, my lord, deed number 6517 in 1998, my lord. That I have purchased the land from one Doyal Chandra Sil, my lord.
Okay.
Now, my lord, in this land, my lord, now title suit also one going on, my lord. In the Court of Civil Judge number 1 Kamrup Metro, page 13, my lord. I filed this title suit, my lord, against the complainant, my lord.
Okay. What is your name?
Yes.
No. You are Mamuni Das?
Yes, Mamuni
Deka.
Deka, my lord.
Okay.
And my lord, order title suits order is page 20, my lord. They have also purchased the same land, and our claim is that we purchased from one Doyal Chandra Sil, my lord. There is a sale deed, my lord, in 1998, my lord.
Where is the FIR?
FIR is page 8, my lord.
What is the allegation?
Allegation that our sale deed was, my lord.
Fraudulent.
Yes, my lord, fraudulently, my lord. But my lord, certified to be true copy, and that is my
No,
lord.
whether this, there is,
And my lord, in title suit, my lord, as per FIR, my lord, they have, my lord, 1 kotha 14 lesa covered by DAG number 52 of KP Pattar, 1 kotha 14 lesa, and we have purchased, my lord, 3 kotha land, my lord. In, my lord, our title suit, we have, my lord, given statement, my lord, page 14. We have purchased 3 kotha, and they have said that 1 kotha 14 lesa they purchased, my lord, complainant purchased.
okay.
This, my lord, case and title suit is going on, my lord, status quo maintain order of the court, my lord, that is, my lord, status quo as on today as regards the nature and character and possession of the suit land till the next date, my lord. It was, my lord, order.
This is the original or photocopy?
No, that is, my lord, certified copy, my lord.
That is what, there is a, my lord, since only the certified copy is available
Yes, my lord.
with the office and also with the petitioner, my lord. The original, as per the petitioner, my lord, the original was lost, my lord. That is what their claim is. But as per the informant, my lord, and so far the deed they have submitted before the IO, my lord, it says, my lord, they have purchased that land in the year 1994. And after that, all the land documents are also there, my lord. But they have said that they have purchased it on 1998.
No, but that is a civil dispute.
Yes, apparently, my lord,
Dispute is,
Yes.
if forgery is there, that maybe,
yes, whether, yes,
now whether forgery is
for
there,
that investigation is going on, my lord. And not, now that, same, the certified, the documents have been, seized from the registered office, my lord. But the investigation is
for-
not yet
for
complete.
the same, his,
Yes, ma'am.
her custodial detention may not be, whether it would be
No.
necessary.
Yes.
Heard Mr. M. Kalita, learned counsel for the petitioner. Also heard Mr. M. P. Goswami, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Srimati Mamuni Deka, who is apprehending her arrest in connection with Boshishta PS case number 689/2023 under section 120B/420/468/471 of the Indian Penal Code. The gist of accusation of this case is that on which date?
Yes, my lord, on 7/11/2023.
On 7/11/2023, one Pradeep Gogoi had lodged an FIR before the officer in charge of Vashishta Police Station, inter alia, alleging that no, not Pradeep Gogoi.
On behalf of
Okay.
Pradeep Gogoi lodged FIR on behalf of Ranjana Gogoi.
That inter alia alleging that one Ranjana Gogoi, who is the wife of the first informant, had purchased a plot of land measuring 1 kotha 14 lechas covered by Dag number 52 of KP Patta number 44 of Revenue Village, Horusajay, under Moja Beltana by executing deed number 1654 dated 18/3/1994. And said land was mutated also.
Yes, yes.
Yes, ma'am.
In whose name?
Mutated, my name also. Mamoni.
In her name also mutated.
Yes, ma'am.
Also mutated in the name of Ranjana Gogoi. However, it came to the notice of the first informant that your deed number is
My deed number is 6517/98.
that the petitioner and one Tapas Chaudhary tried to encroach the land by on the strength of a forged and backdated sale deed number 6517/1990. Stop. It is alleged that a group of people along with are engaged in preparing forged backdated sale deeds in collusion with the staff of Sub-Registrar's Office, Kamrup Metro, with a view to forcefully capture the land belonging to genuine purchaser and pattadars. Stop. Learned counsel for the petitioner has submitted that the petitioner had purchased a plot of land measuring about 3 kattha from one From whom you have purchased?
Duyal Chandra Sil,
From what Dayal Chandra Sil in the year 1990
1998.
by executing the sale deed number 6517/1998. The learned counsel for the petitioner has also produced a certified copy of the said seal deed and has submitted that the allegations leveled against the present petitioner in the FIR are false. And she is the owner of the said plot of land. It is also submitted by learned counsel for the petitioner that the petitioner shall operate in the investigation and hence may be allowed to go on anticipating bail as she is apprehending her arrest in connection with the aforesaid case. On the other hand, learned additional public prosecutor has produced the case diary of Vashishta PS case number 689/2023 and has submitted that though the investigating officer has seized the certified copy of the sale deed from the office of sub-registrar, however, the original copy of the sale deed of sale deed bearing number, what is the number?
Deed is minus 6517
6517
public 98.
/98 would not be found. What is else your submission?
My lord, now the matter, since my lord, my submission is since that the informant has purchased the land, my lord, earlier to the, my lord, this accused persons, my lord. That is why, my lord, as per the note of the IO, my lord, they said that the second deed might be fake, my lord, but it is not.
Amita, in the petitioner's column, petitioner's lawyer submission, learned counsel for the petitioner has also submitted that the petitioner has also filed a title suit before the court of learned civil judge
number 1, Kamrup Metro.
Civil Judge number 1, Kamrup Metro,
Five title suit
which was
number.
registered as title suit number 209/2023. And against whom you have filed? Against the
Complainant.
complainant.
One of the complainant, number 2, Srimati Ranjana Gogoi.
Ranjana Gogoi, who is arraigned as defendant number 2 in the said title suit. Stop. Next last. Ye upar jayega, next. I have considered what is the progress of the investigation?
The investigation as per last note, my lord, that further investigation is required for, my lord, determining the authenticity of the documents.
The statement have been recorded of the witnesses.
Yeah, some witnesses were recorded, my lord.
The statement of the investigation on perusal of the case diary of Vashishta PS case number 689/2023, it appears that the investigation has fairly progressed. And as the allegation is regarding forgery only, forgery of the deed, which the present petitioner claims to be genuine. The evidence claims to be genuine, the custodial detention of the present petitioner does not appear to be necessary. In view of above, the petitioner is directed to cooperate with the investigating officer of Vasishtha PS case number 689/2023. And in the event of arrest of the petitioner in connection with Vasishtha PS case number 689/2023, she shall be allowed to go on bail of rupees 30,000 with one surety of life amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. He will not surrender before police, not surrender.
She can give the statement, my lord, with this order, my lord,
Where
before the IO, my lord.
I has to come to her house.
Mm,
So therefore I have mentioned that she's a lady.
Lordship.
So police she will cooperate whenever
Okay.
IO comes to record her statement, she will give her statement.
Yeah, that part may be.
With above observation, this anticipatory bail application is hereby disposed of.
And
Then-
and my lord, some allegations are there, she shall not exercise threat on the informants.
That condition I have mentioned.
Lordship.
This copy we are keeping in the record. Let the certified copy of the sale deed produced by the learned counsel for the petitioner be kept as a part of this case record.
Maybe this copy may be.
A copy of this sale deed may be kept as a part of case record.